Good morning. My name is Betty Widgeon. I am the appointed master in this matter today. And this is the complaint against the Honorable Bruce Morrow. This is formal complaint number 102. Counsel, please place your name on the record.
Good morning, Your Honor. Laura Weingarten. I am one of two co-disciplinary counsel.
Thank you.
And Lynn Helland, and I am with her, and I am the other disciplinary counsel.
Thank you, Mr. Helland. Mr. Campbell?
Your Honor, Donald Campbell, co-respondent counsel on behalf of Judge Bruce Morrow.
Elizabeth Jacobs, co-respondent counsel on behalf of Judge Morrow.
Thank you. Good morning, Judge Morrow.
Good morning.
All right, thank you. Counsel, I think we are ready then for the next witness to be called, who is in the waiting room, unless there are any preliminary matters. Are there any preliminary matters at this time before we call this witness in? Ms. Weingarten?
There is one preliminary matter, Your Honor. Robert Donaldson was on my witness list, and both I and Mr. Campbell intended to call him. He is unavailable, and we both, I believe, will waive his presence.
Thank you. Mr. Campbell?
That's accurate, Your Honor.
All right, thank you. Is there anything further before I bring Chief Bivens in from the waiting room?
No.
No, Your Honor.
All right, thank you. I'm going to admit him at this time. Good morning. Chief Bivens, are you able to hear me? Right now, it looks like you are muted.
Okay.
Good morning. Are you able to hear me, Chief Bivens?
Yes.
Thank you. My name is Betty Widgeon. I am the appointed master in this matter, and we will start with me swearing you in. Let me just ask you to state your name and to spell your full name for me on the record.
Okay. Good morning, everyone. James A. Bivens Jr. That's James. A as in Adam. Capital BIV as in Victory. ENS. And Jr. JR.
All right. Thank you. Please raise your right hand to be sworn in. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. There are two other matters that I read for you. These are orders that I have signed that are in effect until the proceeding is over. The first one has to do with the sequestration of witnesses. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master or the proceeding ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing his testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and from accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to discovery of the failure or violation. Do you understand that order, Chief Bivens?
I do.
All right, thank you. The second one has to do with witness protocol. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you're testifying right now?
I am.
All right, thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant trial or proceeding exhibits pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand that order, Chief Bivens?
I do.
And do you swear or affirm that you have abided by these two orders and that you will continue to abide by them unless you are released by the master or until the proceeding has concluded?
I do.
All right, thank you. I think we are ready then for the examination and cross-examination. Mr. Campbell, anytime you're ready.
Thank you, sir. Could you state your current occupation and your rank?
I'm sorry, what did you call me?
I said, sir, could you
Oh,
please?
sorry. Okay. I thought you said sheriff. I'm sorry.
Sorry. I'm waiting for you to state your current occupation and your rank.
My current occupation is a chief of the Criminal Investigation Division for the Wayne County Prosecutor's Office.
Thank you. I'll refer to you now as chief if that's okay.
That's fine.
Thank you. Chief, you made a memorandum dated July 8th, 2019 to Kim Worthy. Do you remember that?
I do.
Kim Worthy is who?
She's my boss. She's the Wayne County Prosecutor.
And as part of that memorandum, you incorporated some information from interviews performed by Detective Kinney. Is that correct?
That is correct.
And who is Detective Kinney?
Detective Kinney is one of the detectives assigned to our office.
How long has she worked for you?
For about since 2007, maybe. So.
How long have you thank you. How long have you known Detective Kinney?
For longer than that. We used to work together at Homicide in Detroit. So 20 years or better.
Have you formed an opinion as to Detective Kinney's reputation for truthfulness?
Yes.
What is that?
That she's very, very truthful.
How long have you been involved in law enforcement?
For a total of 43 years.
Is it fair to say that you agree with this statement, that when you take a statement from a witness, it's important to be accurate?
As accurate as you possibly can, yes.
It's also true that you are relying on that witness to be accurate themselves, correct?
Yes.
In the memorandum, as part of the investigation that occurred that created this memorandum, there were a number of people interviewed, correct?
That's correct.
You interviewed some of them. Is that true?
Yes.
And Detective Kinney interviewed two people, Ms. Chiffone and Ms. Bickerstaff, correct?
Correct.
Before conducting this set of investigations that led to the memo, did you know Ashley Chiffone?
Yes.
Did you know Anna Bickerstaff?
Yes.
I'm going to draw your attention, if we could put up screen 91. Judge, can we have a share screen function if it's not already active?
Certainly, you may. It's active.
Thank you. And also, Judge, could we have the witness pinned for purposes of the examination, please?
I have already pinned the witness. Thank you.
Thank you. So, Chief, drawing your attention to the screen, this is the cover page of the memo that you made for Prosecutor Worthy, correct?
It is.
Who, in addition to Prosecutor Worthy, did you provide a copy of this memorandum to?
No one else.
Were you ever in a meeting with Prosecutor Worthy concerning this memo?
Not concerning the memo, no.
Were you ever in a meeting with Prosecutor Worthy concerning the events that led to or created this memo?
Yes.
Who else was in that meeting?
I believe it was just her and I at the time.
You say at the time, was there somebody else later?
No, but at the moment that we discussed this matter, it was just her and I.
Thank you. I'd like to now have page 93 put on the screen.
93.
Yes.
I don't have page 93.
So appearing in front of your screen, Chief, should be the third page of your memo.
Oh, page 3.
Correct. It's my screen 93.
Oh, okay.
And you can see, I've pulled out from that the first paragraph. This paragraph was placed by you into the report, correct?
That is correct.
You see in the middle, actually, I guess it's the second full sentence
Yes.
on the page, reads, she added that she felt Judge Morrow was trying to hit on her because of what he stated regarding sex and foreplay. Do you see that?
Yes, I do.
Those are words that you added to this report, correct?
That is correct.
And the she that you're referring to is Anna Bickerstaff, correct?
That is correct.
It's true that Anna Bickerstaff did tell you that she felt Judge Morrow was trying to hit on her because of what he stated regarding sex and foreplay, correct?
That is correct.
I want to go to page 96 of my screen. I think it's page 6 of your report. And Chief, so the record is clear, I did ask you to have a copy of your report available, and you do have that in front of you, correct?
That is correct.
This is a paragraph that refers to an interview of an assistant prosecuting attorney, a supervisor at Wayne County Prosecutor's Office named goes by Bob Donaldson, correct?
Correct.
You interviewed Bob Donaldson, correct?
That is correct.
So, and so we're clear, while Detective Kinney interviewed Ms. Bickerstaff originally, you separately did meet and speak with Ms. Bickerstaff, correct?
That is correct.
So it says, as part of this paragraph, you can read it, it's in the middle, it says, upon hearing what happened in the case, before we get there, I'm sorry. It says, writer interviewed APA Robert, quote, Bob, unquote, Donaldson, who stated that he was walking down the hall and heard someone say something about sex. Do you see that?
Yes.
That is what APA Donaldson told you happened and why his attention was turned to the group of APAs who were talking down the hall, correct?
That's correct.
In fact, in the next sentence, he describes them as a group of people, correct?
Correct.
Can we go to what is screen 100? Before we put that up, though, if you can have it ready. Chief, you and I have been talking over the last couple of weeks in order to arrange your testimony via Zoom, correct?
That is correct.
We were unable to get you in on the last date, although you were scheduled to testify because of some snafus. Fair?
That's fair to say.
As a result of the issues that we encountered on the previous date, I asked you to please be available and to practice and test out your Zoom capabilities. That's correct, right?
That is correct.
We actually had a trial run on Friday, today's Tuesday, so the immediate past Friday, we had a trial run, you and I, correct?
That's correct.
And you were at home, and to be honest, between and betwixt us, that didn't work out very well, right?
No, it did not.
We were able to talk over the phone, and eventually I think we even had a slight Zoom connection. But we decided on Monday, which is yesterday, we would do this again. And we would make sure you were in your office and I was in mine, and we would make sure that your office connection was sufficient. You remember that?
I do.
So all during this time, Chief, the other thing that I had been asking you about during all of our conversations was, hey, there's a set of statements that Detective Kinney testified about that are evident even from your memo, because you say that Detective Kinney took statements. And so I asked you if you had found those statements or could find those statements or knew where they were. Do you remember that?
I do.
And you told me that you were looking for them. At one point, you thought you might know where they were, but ultimately, you have advised me that you could not find those statements, correct?
That is correct.
Now, let's be clear here. Detective Kinney, are you aware of how she prepares her interviews or her handwritten reports for witnesses that she interviews?
I am.
Okay, and you're aware that she does what's called a question and answer format, where she'll write out a question and then she'll write out the answer that she received?
Yeah, we call it a Q&A.
Thank you. And so you're familiar with the Q&A form, fair? You also know that Detective Kinney has a habit and routine of having the person whom she has taken the Q&A from reviewing that product that she's created. She's written the question, she's written the answer based on the information she received, right? She has the people review them.
Right.
She also has them sign it to affirm that the information that's on there is correct.
That's correct.
Now, separate and apart, Detective Kinney also keeps notes of a conversation in an interview that she may do, correct?
Correct.
So this Q&A form should exist. You would agree with me?
It exists.
You agree with me that you have been unable to locate it, correct?
That's correct.
You agree with me that you have exhausted all of your abilities that you can reasonably think of to try and find them, correct?
That's correct.
You will agree with me that at some point you had those Q&As in making your memo that we have here, correct?
That's correct.
To your knowledge, are you the last person to have the Q&As?
I'm sorry, what was the question again?
I think I remember this one. To your knowledge, are you the last person to have the Q&As?
To my knowledge, yes.
And it's fair to say, I'll withdraw that question and I'll start another one. So the last report I got from you was, bless you, Monday.
Bless you.
Yesterday. The last report I got from you was that you could not find the statements. Do you remember telling me that in our conversation related to testing the Zoom?
I do.
You had, however, recovered some documents, including some handwritten notes by Detective Kinney. Is that correct?
That is correct.
And you had handwritten notes that you found with your handwriting, correct?
I had those all along. I didn't just find them. I did have them along, yes.
Is there a reason why you didn't tell me that those existed?
Because the information contained in those notes are contained in my report.
You did give those documents that you had all along, that includes the handwriting of Detective Kinney and your handwriting, to the JTC staff, Laura Weingarten in particular, correct?
That one note that Detective Kinney, she just found that.
Okay, so that would be the first page of the documents, at least I assume that I received, and probably the first page that you put together. And that had Detective Kinney's and your handwriting on both, correct?
That is correct.
Excuse me, counsel. The witness said she just found that. Which she are you talking about?
I'm sorry, Detective Kinney?
Yeah, I was going to explore that. So this is Detective Joanne Kinney, whose handwriting appears on the page. That's the document that you're referring to as being just recently found, correct?
That's correct.
When was it given to you by Detective Kinney?
The day I sent them off to Ms. Weingarten, same day. I don't exactly remember what day. Just a couple of days ago, maybe. Or a day
I have
ago.
an email. Thank you. I have an email that Ms. Weingarten produced to me from you that is dated December, I think it's the 11th, 10th, December 10th, which is Friday,
Okay.
at about 1:22 p.m. In other words, the date of your email to Ms. Weingarten is December 10th at 1:22 p.m.
That sounds right. That sounds about right.
You and I did our Zoom meeting at about noon. It took us, again, probably 20, 25 minutes to try and connect on Friday, but we ended our Zoom somewhere around 12:30. Do you remember that?
I do.
Did you receive, because you were home, right, when we did this Zoom?
That's correct.
So you must have had the Joanne Kinney note before you were home on that Friday, correct?
If I'm not sure, I might have. I'm not sure.
Did you see Detective Kinney at your home between 12:30 and 1:22 p.m. on Friday, December 10th?
Am I home?
Yeah.
No.
Did you get any documents from Detective Kinney in any format between 12:30 and 1:22 p.m. on Friday, December 10th?
No.
Is there a reason you did not share with me? Okay. To the extent that I've referred to Friday as the 10th, as we all know, lawyers can't count. It is the 11th, and I'd ask that to be understood as my question. Would your answers be any different if Friday was the 11th?
His email was on the 10th.
Can I see his email?
I'm
We're
sorry.
gonna put the email. Let's end this because I thought your email was on Friday. It looks like your email was on Thursday, the 10th. So let's end the mystery. But Friday is the 11th. I think we take judicial notice of that. And there it is. So Thursday, December 10th. You can see that screen, Chief, is that correct?
Yes.
So on Thursday, December 10th at 1:22 p.m., which is 12 hours or so, sorry, 24 hours or so before we do our first of two Zoom practices, you've already alerted Ms. Weingarten to the fact that you had found, that Ms. Kinney had found and provided you the note that you were sending to Ms. Weingarten, correct?
That's correct.
This is an accurate email of what you sent to Ms. Weingarten, correct?
That's correct.
Give me a moment. I have to do an adjustment on the screen so I can read it. You wrote, quote, first of all, this is Ray, hi from Laura. Do you see that?
Yes.
So it was, am I correct that this is part of a longer string of emails between you and Ms. Weingarten?
I believe it is.
In this email, you write Laura, comma, Joanne found her notes, comma, on which I wrote the following, quote, she felt that he was trying to hit on her in and around about way, comma, felt it was improper, close quote, period. This occurred after Joanne had taken her statement, which is properly why it was not in her written statement, period. After looking at the notes, comma, I do recall her saying that, period. Again, if it wasn't said, you would have not seen it in my report, period. I've read that accurately, correct?
You did.
I'd like to put up screenshot 100. Chief, this is a screenshot of the portion of the page, because it was a single page that Detective Kinney gave you, correct, with handwriting on it.
That's correct.
So this is a screenshot of the bottom, it's not the full bottom, but it is, oh yeah, it is the full bottom third of that lined piece of paper. think
Yes.
I'm up to Exhibit N as in Nancy. So for identification purposes, I'll refer to this as Exhibit N. There are dark handwritten words and there are lighter handwritten words. You would agree with me between the contrast that exists on this portion of the page, correct?
Excuse me, I do.
The darker handwriting appears to be different to my eyes than the lighter, by contrast, handwriting. You agree with me?
I do.
Do you recognize the darker handwriting?
I do.
Am I correct that it is Detective Kinney's handwriting?
You are correct.
The lighter handwriting you recognize as your own, correct?
It is correct.
And your lighter handwriting, right after the name Anna Bickerstaff, written by Detective Kinney, you wrote the phrase that is contained, the sentence that is contained in your email and highlighted in quotation marks for Laura Weingarten, correct?
Correct.
You also have handwriting in the margin of this document that is yours, correct?
Correct.
It says for a judge to be discussing with her regarding a homicide trial. Is that an accurate reading of what's in the margin?
Correct.
You think that's not? For a judge to be discussing sex. I'm sorry, I forgot a big word there. So let me write that, let me make the record clear here. The full handwritten statement is for a judge to be discussing sex with her regarding a homicide trial. Do you see that?
Yes.
Is that something Anna Bickerstaff told you, or is that your own reflection?
No, that is something that Ms. Bickerstaff said.
Thank you. We've talked about Detective Kinney's habit routine regarding witnesses taking statements, preparing documents, having information affirmed or confirmed by those whose information has been taken down. Do you have a habit routine for ensuring that the information you take down is accurate, or at least that you pass on to others?
I do.
Is part of your habit routine, let me ask in this case, did you show to Ashley Chaffone, for example, the portion of the write-up that you did for her in your memo that was going to Prosecutor Worthy?
No.
Did you show the portion in your memo to Anna Bickerstaff?
No.
If Anna Bickerstaff testified that she saw the portion in your memo and that she did so in your office because it was provided by you, would you say that that was incorrect, or is it possible you've forgotten it?
It's possible I've forgotten.
If Ashley Chaffone testified that she saw her paragraph before it was submitted as part of the memo, also, it may be that you forgot that.
Okay, that's possible.
And if both of them say they were in this room together with you to look at the final product, that's still possible, correct?
That is, because I do recall talking to them both at a couple of times, couple of points in time. So that's quite possible.
Thank you. If I may have just one moment, Your Honor, I'm going to mute here. I believe I have completed my examination, but I want to be sure.
Certainly.
I don't know if that got on the record there, comment from my co-counsel. I hope it did, but At this point, I have no further questions for this witness. Thank you, Chief Bivens.
Thank you, sir. Thank you.
Thank you. Ms. Weingarten?
Good morning, Chief.
Good morning.
You testified that Joanne Kinney was a Detroit Police homicide detective and then now is a detective with the Wayne County Prosecutor's Office.
That is correct.
And you testified that your opinion of her reputation for truthfulness is very good, right?
It is.
Do you think she's a good judge of when someone is faking emotion?
Yes. Yes,
Based
indeed.
on her experience over the years?
Based on experience and the time I've spent with her homicide, that she's a pretty good judge of what's going on from a particular person that she talks to. Yes.
Okay. When you typed your memo, which has been shown to you and which you have, did you expect that memo ever to be turned over to the Judicial Tenure Commission?
No, that's not up to me. I give that to my boss, Ms. Worthy, and then they make that decision. I do not.
Did you ever tell Ms. Bickerstaff or Ms. Chaffone that memo would be turned over to the Judicial Tenure Commission?
I don't recall telling them that, no.
Okay. So how did this, I want to go through the steps of how this investigation took place within your office. How did you get assigned to investigate the situation?
It was assigned to me by the prosecutor.
Kim Worthy?
Yes.
And then what did you do to get the investigation moving?
I just began to interview people.
Did you initially, I'm sorry.
And I assigned Detective Kenny to the case.
Did you initially interview either Ms. Bickerstaff or Ms. Chaffone?
Initially, yes, real briefly.
Did you take any notes about those interviews?
I did take some notes. Whatever notes I have, that you should have them. That's all I have.
All right. The notes you say that I should have, is that what counsel put up on the screen this morning?
Yes.
Right. Besides those notes, are there any other notes I should have?
No.
So you initially talked with both of the women, and then did you?
Laura, I don't mean to interrupt, but just so the record is clear and so you're clear, and so I'm clear. I used a portion of the top page of the documents you sent me, Laura. There are a number of more pages, but I just want to make sure that was clear.
Okay, so thank you. All right, so Chief, how many different pages was your investigation in handwriting?
In handwriting? Let's see. 1, 2, 3, 4, 6, 7.
All right, and how many witnesses did you assign Joanne Kinney to interview?
2.
Which 2?
Anna Bickerstaff and Ashley Siobhan.
Did the fact that Miss Kinney was female have any play into your decision to have her interview the 2 women?
No.
And the notes that you have, do they contain Joanne Kinney's writing?
No, they are all mine. And I should correct this. I did not take notes from Ashley and Anna because I knew I was going to have Joanne Kinney take a statement, so it wasn't necessary for me to take notes at that point.
The notes that you've just referred to that are about, I think you said 6 or 7 pages.
Right.
Do they have Joanne Kinney's writing on it?
No.
All right. I thought when you testified on direct examination, Mr. Campbell was referring to darker print and lighter print. Is that correct?
That's correct.
So was either the darker print or the lighter print Miss Kinney's writing?
The darker print was Miss Kinney's writing.
All right. Now, you told us that Miss Kinney's habit is to take a Q&A from the witnesses and have the witnesses review it and sign it. Is that right?
That's correct.
And those are the documents that you've been looking for, but have been missing since the beginning. Is that fair to say?
Yes.
Now, after Miss Kinney took those statements, do you know what she did with them?
She gave them to me.
Did you ever review those statements with Miss Bickerstaff or Miss Chaffone?
I don't recall doing that now.
Were you aware that before an investigation was done by the Wayne County Prosecutor's Office, Miss Bickerstaff and Miss Chaffone wrote out or typed out 2 memos? about the situation.
I am.
Did you read those memos before you typed your report?
I did.
Did any of the information they wrote in their memos make it into your report?
Yes.
After you wrote the report, well, by the way, what date did you write the report?
On the 8th of July, 2019.
Besides you and Miss Kinney, did you have other detectives helping you interview the staff people that you interviewed?
No.
So you took Joanne Kinney's statements from the two women and their memos, and you wrote the paragraphs that are now in your typewritten memo. Is that fair to say?
That's fair.
And you don't really recall whether or not you had Miss Bickerstaff or Miss Chiffone review your typewritten report?
I do not.
It's possible you did, but you're not sure.
That's correct.
Did you ever confront Miss Bickerstaff that something she said to you was not in what her statement to Joanne Kinney or in her memo?
No.
Were you aware that the statement about her being hit on by Judge Morrow was not in her statement to Joanne Kinney and was not in her memo?
I'm going to object to foundation. We don't have the statement to Joanne Kinney, or Detective Kinney. We don't have that. The Q&A has not been produced.
That's true, Judge, but Ms. Kinney testified that Anna Bickerstaff did not say that, and it was not in her Q&A, and Ms. Bickerstaff confirmed that.
No, very important here, Judge. Detective Kinney said she didn't recall Ms. Bickerstaff saying anything about being hit on. She did add, and this is the same line that's in that document that was on the phrase, she knew what he was intending or doing. That was her testimony.
Judge,
So
obviously,
contrary. I can get that by page number if you want, but that was the testimony of Joanne Kinney.
Judge, obviously it's up to your memory of what Joanne Kinney said, but she very strongly said Ms. Bickerstaff did not tell her that she felt Judge Morrow was hitting on her.
You give me a moment, I'll give you the page set.
All right, let's take a moment and see that page.
Page 833 of the transcript, Your Honor. This is during Detective Kinney's testimony. She testified that Anna B. said, quote, "I know what he was trying to do," end quote. Detective Kinney adds, hitting, comma, "I'm not sure about that," period. So, and that's the testimony, Judge. You can look at it on page 833. I can't swear to my punctuation, but I'm pretty confident on the words. These are my notes from the transcript.
Judge, I don't have the transcript with me here today. I wish I did, but I hope that you remember that her words were very strong when she said Ms. Bickerstaff never told her she felt she was being hit on. And if we need to take a break so we can get into our email to get the transcript and find the pages, we should do that.
I have the transcripts here.
All right, I'm going to call for a 10-minute break at this time for counsel to review that transcript. I'm going to take you into a sidebar room. The witness, please remain where you are, and we will do that.
If I may, Your Honor, and I do want to finish this. I know Chief has a doctor's appointment. He told me about that, so I don't want to delay this while we, is there any way to continue or at least finish the questioning, and then we can resolve the issue of what it is that Detective Kinney said or didn't say, and we can create a separate record for the answer as the questions posed, and then we can decide whether that's going to be part of the full transcript or not. I'm trying to be kind of the...
One moment. Chief, do you have a time constraint that we should be aware of at this time?
Yes, I do. I'm going to be late as it is, but I do have a doctor's appointment at 10, actually. I thought we might be done by 9:30 or so, but I'm going to be late, but yes, I do.
All right, thank you. Ms. Weingarten, any response?
Well, may I propose something? If council will agree to stipulate to the testimony in the transcript from Joanne Kinney, we solve this problem.
Sorry, can we have that again?
I said if council would agree to stipulate to the transcript testimony of Joanne Kinney about whether Ms. Bickerstaff told her that she believed Judge Morrow to be hitting on her, then we can solve this problem and move on.
Again, yeah, I'm looking at it now, page 833. My questions between lines 6 and 17.
All right, so are you stipulating to that, Mr. Campbell?
I'm stipulating that what Joanne Kinney said, she said, yes.
Thank you.
I don't know what lines 6 through whatever Mr. Campbell said say, but I want the opportunity to look at the transcript and find other pages where I am certain Ms. Kinney said what I said she said.
Right. Well, we certainly have Ms. Kinney's, Detective Kinney's transcript, and I am not looking at it at this time either. So we will certainly, if there is a stipulation that the transcript says what it does, and whenever she spoke about that particular issue, that that is what her testimony was. Is that
I will
a
stipulate
stipulation
to that.
between the two, counsel?
Absolutely.
All right, thank you. Continue, please.
Okay. Chief, after you finished typing your memo, what did you do with it?
I took it to Ms. Worthy, prosecutor.
And do you know what was done with it after that?
No.
Is there a reason after Miss Joanne Kinney interviewed the two women that you went back and interviewed Miss Bickerstaff yourself and added that one light colored line in your document?
I'm sure there was. I just don't recall what it was.
Normally, do you trust Joanne Kinney to do a good, thorough interview of witnesses?
Oh, indeed, yes.
Can you read to the judge the totality of the statements you wrote on that document in the lighter ink?
On the note?
Yes.
She felt that he was trying to hit on her in a roundabout way. Felt like it was improper for a judge to be discussing sex with her regarding a homicide trial.
Who made that statement to you?
Anna Bickerstaff.
Thank you. Nothing further.
Mr. Campbell.
Judge, today, I'm going to get the date right, I'm sure of it this time, December 15th, 2020, Anna Bickerstaff has never come to you and indicated that she made a false statement to you when she gave you that information, correct?
That's correct.
Thank you. I have no further questions for this witness. He can be excused.
Thank you, Ms. Weingarten. Anything further?
Yes, but you don't even remember if Miss Bickerstaff ever reviewed your memo. Is that correct?
Don't.
I'm sorry, what was your answer?
I do not.
Thank you. Nothing further.
If I may, very briefly, as
Very
response.
briefly. Go ahead,
Thank you.
Mr. Campbell.
Chief, it would be very memorable if somebody came in to you and said, "Hey, Chief, I lied when you interviewed me," right?
Yes.
Thank you.
Ms. Weingarten, last opportunity.
Chief, if someone doesn't correct something that you say, would you characterize that as a lie?
No,
Could it be a mistake?
could be.
Objection calls for speculation.
Objections overruled. All right, is that it, Ms. Weingarten?
Yes.
Thank you. May this witness be excused, counsel.
Yes.
Mr. Campbell?
Actually, I have a follow-up on that last set of questions since you overruled that objection, if I may.
Go ahead, Mr. Campbell.
Chief, you're
Yes.
aware that lying to a police officer is a crime, right?
Yes, I put that in motion, that particular law that we have now.
Chief, are you a police officer?
I am.
You were investigating a matter on behalf and at the direction of the prosecuting attorney for Wayne County, correct?
That's correct.
You would agree that was an official duty?
Yes,
You agree that you expected the highest level of candor from those lawyers at the Wayne County Prosecutor's Office that you interviewed, correct?
I do.
Thank you. I have no further questions.
Thank you. Ms. Weingarten, anything further?
No.
Counsel, may this witness be excused.
Yes.
No objection.
Thank you. Chief Bivens, you are excused from your testimony. I have told all the witnesses that the sequestration order and the witness protocol order are still in effect and will continue to be in effect until the proceeding has concluded or until you are specifically released. At this time, though, we will release you from our proceeding. Thank you.
Okay, thank you, Judge. And everyone stay safe. May I leave now?
Yes, you certainly may.
Okay, thank you.
All right. Counsel, are we ready for your next witness?
Your Honor, I have no further witnesses to call. Before I rest, I would move admission of my exhibits that I have, but that's the last thing that I do. I don't want to hold up the next witness if he's ready to go and in the room. As long as I'm allowed to do that at the end of the next witness, we can do it then. But if you prefer to have me do it before I close my case, I would have to do it now.
All right, thank you. The next witness is in the waiting room. I don't know of any time constraints. It should only take a minute for you to do that. So why don't you go ahead and do that now?
List. Your Honor, I would move admission of respondents' proposed Exhibit A into evidence as Exhibit A. That's the Register of Actions for People versus Matthews, the underlying criminal case 18-007-023.01.FC.
No objection.
Thank you. It is
I would
admitted.
move for admission of Respondents Exhibit B, the circuit court file, at least the portion of that, which is the motion to disqualify and related documents for that same matter, People versus Matthews.
No objection.
Your Honor, I would move admission of the transcript from the Wayne County Prosecutor's Office motion to admit other acts of evidence held on May 15th, 2019 from the People versus Matthews case.
That's the one in front of Judge Michael Hathaway?
This is the one on May 15th, 2019 in front of Judge Morrow.
Okay, no objection.
Thank you. Your Honor, I would move for admission of Exhibit D, proposed Exhibit D, Respondents Exhibit D, as Exhibit D. It is the Register of Action for People versus Matthews Court of Appeals matter, which is given case number 349123 in the Court of Appeals.
No objection.
Your Honor, I would move for admission of proposed Exhibit F. And so we're clear, I am not moving for proposed Exhibit E. There are no documents behind that tab, and it was a place saver. But now I'm moving for proposed Exhibit F, which should be the Court of Appeals order in People versus Matthews, the same case numbers I've just given, related to the decision on the 404B evidence prior to trial.
No objection.
Your Honor, I have marked as respondents proposed exhibits G, the transcripts. I believe that they have been separately marked and have even been admitted previously by disciplinary counsel. Assuming that's true, I don't need to move for admission of exhibit G. Do you agree, counsel?
Which transcript are you referring to?
These would be the transcripts from the trial.
Correct. I believe they've already been admitted.
Thank you. I next would move for admission of proposed exhibit I, which are transcripts from the arguments before Judge Michael Hathaway regarding the 404B evidence in People versus Matthews. These are the arguments from September 23rd, 2019.
No objection.
I'd move admission of exhibit K, which are the pictures of Judge Morrow's courtroom.
No objection.
I would move for admission, and I believe they've already been admitted, as if they haven't been, just in case, proposed exhibits L and M. Exhibit L is our stipulation that was read into the record, and exhibit M is the recorded recollection in terms of the note and memo that I received from Ms. Weingarten on October. Well, it's dated October 1, 2020.
I believe they have already been admitted, but we don't object.
And lastly, I would move for the admission of exhibit N, which is new to this proceeding with the last witness, and that would be the handwritten information that Chief Bivens just testified to. I would mark the entire page as the exhibit, and that would be what he described as the note, the single page of notes that he received from Detective Kinney.
Judge, I would ask that all 7 pages of his notes be admitted and not just the 1 page.
With that friendly amendment, I have no objection to that.
All right, thank you. And that was in, I believe, the last one, correct?
And yes.
All right, so I have then the respondents' proposed exhibits A, B, C, D, F, G, I, K, L, M, and N. No objections from disciplinary counsel to any of those. They are admitted into the record at this time.
And thank you. We can sort out any, again, counting errors between us, but Ms. Weingarten, I believe that exhibit N, as in Nancy, will be a total of 9 pages.
Are we talking about Mr. Bivens' typewritten report?
Yeah, now does that include the email? I'm looking at my paralegal.
It includes this page.
Yeah. And then the date of it. So, yeah, we have it as the top page is Detective Kinney's handwriting and Chief Bivens, and then we have 8 pages with handwriting of Chief Bivens.
Okay, 9 pages total.
Number, but I just want to let you know my number is different from yours right now. But everything I got from you, so there must be it.
I thought Chief Bivens testified it was 6 or 7 pages long.
I think he did say that, but what I have appears to be longer. More pages.
Then I agree to admit what Mr. Campbell has.
Okay.
All right, thank you. Those exhibits, those proposed exhibits are admitted.
Thank you. With that, the respondents, if I may have just one moment.
Certainly.
With that, I have no further exhibits to produce or witnesses to call, and the respondent's case rests.
Thank you, Mr. Campbell. Ms. Weingarten?
Judge, I also have some exhibits to move to admit. I could do it now or after Mr. Muscat testifies.
How many exhibits do you have, Counselor?
4.
Go ahead and move those admissions.
The people moved, disciplinary counsel moves to admit exhibit 6, which is the memo typewritten by Ashley Bickerstaff.
Any objection, Mr. Campbell?
Yes, but we've used so much of it, we've talked about it. As a formal objection, I think it's a prior consistent statement created at a time when it is in her interest to do so. She testified about how she had told other people about these events. She was told to make the memo, and it is clearly intended for that purpose. So I don't think it qualifies under 801 to be admitted. I think it's hearsay and it should be excluded. But I'll accept your ruling. So I will make the objection. I think that's the right objection.
Thank you. Any response, Ms. Weingarten?
Yes, that memo is admissible for two reasons. One, under 801 D1B, it's a prior consistent statement made before an alleged motive to lie occurred. In his opening statement, Mr. Campbell called Ms. Bickerstaff a liar because she did not correct Chief Bivens' typewritten report. This memo was written before Chief Bivens' typewritten report was made. The other reason is that Mr. Campbell claimed in his opening statement that but for that one line in Mr. Bivens' 12-page memo that Anna Bickerstaff said that she believed Judge Morrow to be hitting on her, we wouldn't be here today. And that memo that both of the two prosecutors wrote shows that there's a whole lot more to it than just one line of one investigation that says what I said it said. It shows that there was so much more misbehavior by Judge Morrow that Mr. Campbell's argument that we wouldn't be here today but for that one statement simply isn't true.
May I briefly respond?
One moment, and that is proposed exhibit, which one?
6 for Ms. Bickerstaff, but I was also going to move to admit Ms. Chiffon's memo, which is exhibit 7.
And yes, you may respond. Mr. Campbell, also, do you know at this point if you have the same objection to proposed exhibit 7?
I do.
All right, you may go ahead and finish your response.
Thank you. Judge, at the time I made my opening statement, it appeared that the only person who had been misled was Detective Kinney, and that it was, or in the alternative, it was possible, because I had not yet spoken to Detective Kinney, she had not yet testified, it was possible that it was Chief Bivens who created the error and went rogue and wrote a point in there. Now we have testimony that from the very outset, Anna Bickerstaff was making up the allegation of being hit on. That's very different. So when counsel says, boy, this is to rebut Mr. Campbell's statement that Anna Bickerstaff was a liar, well, she's admitted that she let the false statement go through and didn't correct it. That is lying. Secondly, we now know that we have testimony from the chief investigator in the Wayne County Prosecutor's Office that she did lie.
All right, thank you. Anything further before I rule, Ms. Weingarten?
Yes, Chief
Wait,
Bivens did.
one second. Mr. Campbell, were you trying to continue? I thought you were done.
I'm sorry, I wanted to sort of punctuate and say she's always had a motive to lie. So everything is designed around that. Thank you.
Thank you, Mr. Campbell. Any final comment before I rule, Ms. Weingarten?
Yes, Chief Bivens did not say today that Anna Bickerstaff lied. He said that she didn't come to him to correct the error in his report. He said it could have been a mistake. He doesn't even know if he showed her the typewritten report and if she reviewed it or not. So that's hardly a lie.
All right, thank you, counsel. For the proposed exhibits 6 and 7, I am admitting them. Continue, Ms. Weingarten.
The disciplinary council also moves to admit exhibit 12, which is Mr. Bivens' typewritten memo.
Any objection?
Yeah, I think to the extent that he's testified to portions of it, that's in the record. Everything else, and it's a long memo, everything else has no bearing. Only Ms. Bergamo, Ms. Bickerstaff, and Ms. Chiffon are in there. And I think there's about a dozen or more other comments and statements. Oh, Mr. Curley's there, but yeah, that doesn't make any sense. he didn't testify to it in that manner as a recorded recollection. He remembered what happened, and he told us what happened. And he told us that his memo was accurate in those portions of that go to impeach Hannah Bickerstaff. That's what that is. Impeachment doesn't come in as evidence. And certainly the rest of it we haven't even talked about.
Response.
I'd leave it to your honor's discretion.
All right. I'm going to consider that for a little bit, and I'll let you know my answer. That was the proposed Exhibit 12.
Yes.
All right. Anything?
Finally, the people want to have marked the People versus Adrian White transcript as exhibit number 16. Council already has a copy of it. Your honor does not. I can email it to you. But it is the transcript in which Judge Morrow injected a hypothetical example of himself having sex in a men's restroom with another man during a non-sex related case involving a privacy issue.
Thank you. Any objection, Mr. Campbell?
But I have objection to the characterization of the testimony, which was about right of privacy and right of Fourth Amendment search and seizure. But beyond that, I don't have any objection to the transcript itself, which speaks for itself.
Right.
What are you going to mark that as, Ms. Weingart?
16.
16. Thank you.
And your honor, when we're done with the proceedings, I'll email it to you.
All right. Thank you. Are there any additional ones?
Not for the disciplinary council, no.
All right. So as to proposed Exhibit 6 and 7, and also 16, I think those are the three. Those are admitted at this time. And with respect to the proposed Exhibit 12 in its entirety, how many pages did you say that is?
9.
9 pages. All right. Now, well, I will talk with counsel about that later. There was another document that I thought we were talking about that was also 9 pages from Chief Bivens. Are these two different documents?
Yes, they are.
Okay. All right. Well, I will let you know with.
And I have to say, they're related, but they are two different documents.
All right. I will let you know with respect to the proposed Exhibit 12 later, but I need to think about that for a bit. Anything else? So the others are admitted. Anything else?
No.
All right. So the other witness is still in the waiting room. Let's just take a very short break, a 5-minute break before I admit Mr. Muscat, and we begin. Thank you. Council, are we ready to continue?
Your Honor, my client is currently not in the room. I expect him back momentarily.
All right, thank you. Ms. Weingarten, you are muted. Yes.
Judge, I was looking for the transcript to send you and I haven't found it yet, so I will send it a little later, but I am ready to continue.
All right, we'll wait for Judge Morrow to return and then we will start.
Your Honor,
Yes.
my client is back. Ms. Jacobs has stepped out momentarily, but she said for us to continue. So I'm
All right.
ready to proceed.
Thank you. At this time, then, I will bring in the witness from the waiting room. Mr. Patrick Muscat appears to be there. Good morning, Mr. Muscat. You are muted at this point. I would ask you to unmute, please.
Good morning.
Good morning. Are you able to hear me all right?
Yes.
All right, thank you. Mr. Muscat, my name is Betty Widgeon. I am appointed master for this proceeding. We're going to start with me giving you the oath. After I give you the regular oath that we're used to, I'm also going to give you information about the amended sequestration order and also the order having to do with witness protocol, and ask you to swear or affirm that you have been following that order and that you will continue to until you are released or until the proceeding has been completed.
Your Honor?
Yes.
I
One moment. I think there was a preliminary matter. Mr. Muscat, before I go ahead with the oath, I'm going to send you back to the waiting room. And I think there is an issue that needed to be put before us at this time. So one moment, please. Yes, Mr. Campbell.
Thank you. If I had not done so already, and I don't remember doing so, I wanted to object. I don't believe it's proper to take this witness. He should have been called in the case in chief. He is on the JTC's witness list. Anna Bickerstaff came in and they knew two things. They knew that she was going to come in and testify that she had not corrected the Bivens memo, right? And beyond that, they knew that Ashley Chaffone was going to come in and say that as early as June or July of 2019, Anna was aware of the false statement and had failed to correct it. That's information I didn't even have, but they brought that out in their case in chief. If they wanted to bolster, for any reason or purpose, the credibility of Anna Bickerstaff, which I understand this is what this witness is going to do. He's going to come in and say that He doesn't know her to be a liar in the same way she's been demonstrated to be so in this case. But that's not proper rebuttal. They're not rebutting anything I have produced. They're rebutting what they have produced.
All right, thank you. Ms. Weingarten, any response?
Yes, Judge, it is clear the defense characterizes Ms. Bickerstaff's failure to correct a line in Chief Bivens' report as a lie. We characterize it as a mistake. But what we're stuck with is Mr. Campbell's opening statement where he calls her a liar, and the testimony of attorney Lillian Diallo, who also called Ms. Bickerstaff a liar. Under Michigan Rule of Evidence 608A, the opposing party is allowed to call rebuttal witnesses as to someone's character for truthfulness. And we're calling Mr. Patrick Muscat to rebut what Mr. Campbell said in his opening statement, as well as Ms. Diallo's testimony.
Thank you. Is there anything further, Mr. Campbell?
Yeah, first of all, I've never heard of rebutting opening statements before. And I don't believe that it's proper rebuttal of any testimony provided on the defense. If you do believe so, you should admit it. But I do believe it's properly should have been brought in their case in chief.
Thank you, Mr. Campbell and Ms. Weingarten. Having heard your arguments and support, I am going to admit this witness and allow him to testify as a rebuttal witness. Is there anything further before I admit Mr. Muscat?
No.
All right, thank you. Good morning, Mr. Muscat, again. All right, at this time, I am going to ask you to raise your right hand to be sworn in. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. The other two orders that I'm going to read to you right now have to do with the sequestration of witnesses. This order and the sequestration remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master or the proceeding ends. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing his testimony in any format or by any means with another witness, from viewing the proceeding on any device, from listening to the proceedings on any device, and from accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by that witness prior to discovery of the failure or violation. Do you understand that order, sir?
Yes, ma'am.
All right, thank you. With respect to witness protocol, hearing and witness protocol, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in that room, sir?
Yes.
Thank you. No witness shall access or review off-screen any documents or other materials beyond the relevant proceedings, exhibits, pleadings, or transcripts before, during, or after their testimony until the proceeding is over. Witnesses shall certify under oath that no one has given them information by any means that the counsel and the master cannot observe to assist while testifying. Devices that witnesses use to testify, that is, for example, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Do you understand that, sir?
Yes, you cut out a couple times during that, but I've read that language before, yes.
All right. I'm not sure when I cut off, if that was in the beginning for you or the middle or the end.
It was a couple times in all three parts,
All right.
but I don't have any devices. My cell phone is off. I just have my laptop that I'm viewing you all on.
All right. And you have stated that you have seen these two orders before, is that correct?
Yes,
Do you swear or affirm that you have abided by these orders and that you will continue to abide by these orders until you are released or the proceeding has concluded?
yes. I brought up the fact that I talked to Ms. Bickerstaff on one occasion. I believe that's been brought to your attention.
All right. You said you talked to her on one occasion, and what was the rest?
Prior to my receipt of those orders, clearly because she's in my chain of command.
All right.
I'm
So
one of her.
you also are going in and out a little bit. So I'm not sure if that's your connection or mine.
I pay for internet connection.
All right. One moment.
So
All right. Start again. What you were trying to say. You pay for internet connection. What was that?
I pay for a high-end internet connection because, and I have my Ethernet cord using Wi-Fi. I can try to call in as well. That sometimes creates a better audio signal if you'd like.
Let me find out from counsel. Is the witness going in and out for you also?
Yes.
Yes. All right.
Ms.
All right.
White,
We definitely, I want you to try and call in. Before you do that, let me finish this part. And that is just to have you state your name and spell it for the record.
Yes, ma'am. Patrick Muscat, M-U-S-C-A-T.
Thank you. All right, Mr. Muscat, you're going to try and call in and we'll see if we can have a better connection for you consistently.
Yes, ma'am. I'm just turning on my cell phone and then I'm going to switch to phone audio. So I'm doing that as we speak.
Right.
All right.
Welcome to Zoom. Enter your meeting ID followed. Enter your participant ID followed by pound. Otherwise, check.
Judge, while Mr. Muscat is
To the
working on
pound,
that, I
please
raised
record
one
your
issue.
name. When you have finished recording, press pound.
Muscat.
Yes, go ahead.
Before you rule on the admissibility of Exhibit 12, I have one more argument I would like to make, but it doesn't have to be right now.
Right, I will discuss that with counsel at sidebar after we're done with the witnesses testifying.
Hello?
Hello, Mr. Muscat.
Is that better?
I can hear the sound just fine. Excuse me. Are you still able to hear us?
Yes, ma'am.
There is a delay between your voice and your video, but I think we will be able to follow that with taking into account the slight delay. All right. I think we're ready then. I've had Mr. Muscat state and spell his name. Ms. Weingarten, anytime you're ready.
Tell the judge again your whole name.
Patrick Muscat, M-U-S-C-A-T.
How are you employed?
I work at the Wayne County Prosecutor's Office,
How long have you worked there?
approximately 27 years.
What is your title and your job responsibilities?
I am currently the Deputy Chief of the Special Prosecutions Division. That's a management role that I oversee approximately 50 attorneys and clerical staff in various units.
Is one of the people you oversee a young woman by the name of Anna Bickerstaff?
Yes.
How do you know Miss Bickerstaff?
I've known Ms. Bickerstaff since she first begun in our office in approximately 2011. She's worked in assignments most of her time here under my supervision, indirect or directly.
Are you a member of the hiring committee at the prosecutor's office?
Yes.
Tell the judge what the hiring committee does.
The hiring committee is comprised of chiefs and a few other attorneys in the office who interview candidates when they apply to be hired as project consultant attorneys or APAs. And we do resume reviews and actual live hearing or live interviews where we then make recommendations for hire to prosecutor worthy.
Do you do reference checks?
On occasion, yes.
Now, you told us that Ms. Bickerstaff was an intern in the year 2011. Is that right?
Yes, I believe that was her first year, yes.
And can you tell the judge what Ms. Bickerstaff's progression was through the office?
Yes, she volunteered as a college student in our office in 2011 and was assigned to the violent crime unit, or strike that, I believe it was the forensic evidence review unit at the time. So she volunteered during the summer, and then she came back the next summer, worked in either the violent crime unit or one of the other units that I supervise. And then eventually she went to law school, and she interned in our office during law school in various units, and was hired as a paid intern during law school, passed the bar, and was hired then as a project consultant in our office, worked in the litigation technology unit, and then I believe also the juvenile life without parole unit. And then eventually she was hired as an APA, and she returned to the violent crime unit and then was selected for the major drug unit recently. I say recently, within the last year.
What does APA stand for?
Assistant Prosecuting Attorney.
If a person starts as an intern, do they automatically progress through the ranks as you've described?
No, and I would note that she's one of the few people that I know that progressed from a college intern all the way up to an APA. That's a little more unusual.
In order for her to progress the way you've described, does someone have to approve her progression?
Yes. At every stage she's hired for a new position, she would go through some type of review by her supervisors, and recommendations would have to be made to continue her employment.
To your knowledge, has she ever been not let's strike that. To your knowledge, has she ever not been progressed because of her conduct or her truthfulness?
No, she's had no problems there. She's progressed in every assignment she's had to the next level.
Do you have an opinion about Ms. Bickerstaff's character for truthfulness?
Yes.
Tell the judge what your opinion is.
I believe that she has a high character for truthfulness. I believe, based on my work with her, that she's a credible person, and I've recommended her for, I guess, what I would refer to as delicate assignments, particularly in the major drug unit, and I'm confident that she has the ability and the character to do those assignments successfully, and she's proven that over the last 8 or 9 years.
Have you communicated with others about Ms. Bickerstaff's reputation for truthfulness?
Yes, I've had to talk with her supervisors in the past during performance evaluations or during case assignments. For example, John Casey is her current supervisor. I've talked with him through performance evaluations about her character in general and her reliability, etc.
And what is her reputation for truthfulness within the Wayne County Prosecutor's Office?
I'd say good, high, reliable, somebody that can be counted on.
Have you communicated with people outside of the Wayne County Prosecutor's Office about Ms. Bickerstaff?
I have. Recently, I received a communication from somebody outside of the office about her.
How recently?
December 3rd.
And tell us who that person was and what the communication was about.
An email was forwarded to me from an APA within our office that came from Craig Summers of the Michigan HIDA organization, which stands for High Intensity Drug Trafficking Area. And that is a subset of a federal program run through the department, the DEA, the Drug Enforcement Agency, that sponsors an opioid / major drug position in our office. And Mr. Summers sent the email.
Objection to anything that Mr. Summers says. It's hearsay.
Judge, he's testifying about Ms. Bickerstaff's reputation for truthfulness, and if Mr. Summers told him something relating to Ms. Bickerstaff's truthfulness, he should be allowed to testify about it. Reputation is always about what other people say.
Mr. Campbell, anything further?
Yeah, it's not about what a person says. It's what the community says.
Thank you. Objections overruled.
Mr. Summers wrote in his email that Ms. Bickerstaff was reliable, efficient, professional, and he thanked us for her assignment to the COMET task force, which is, I don't know off the top of my head what COMET stands for, but it's a special drug prosecution law enforcement task force. And the nature of that kind of work is very, it's very challenging, and she's performed very well. She's provided, according to Mr. Summers, she's provided proficient and good legal advice on the drug charges that they have to deal with, and that they enjoy working with her, and that they can rely on her. And that was the kind of the point of the email Mr. Summers sent to our office.
Excuse me, what are the initials that you mentioned?
COMET was one of the ones I mentioned. That is a drug task force made up of law enforcement officers. I don't know what that stands for off the top of my head. And the other was HIDA, which is the High Intensity Drug Trafficking Association, or areas, which is a group that is funded nationally through the Drug Enforcement Agency.
Your Honor, could I get a repeat of the first one again? Not the HIDA, but the other, please.
COMET. Oh,
COMET.
sorry. Yes, COMET.
Thank you.
And what was Mr. Summers' first name?
Craig.
May I proceed, Your Honor?
Yes.
So what is Ms. Bickerstaff's reputation outside of the Wayne County Prosecutor's Office for truthfulness and reliability?
I would say good.
Thank you. I have no other questions.
Thank you. Any cross-examination for this witness?
Mr. Muscat, ethics is important to the Wayne County Prosecutor's Office. Is that true?
Yes.
Candor is an essential element of ethics for an attorney, correct?
Yes.
And candor is not just saying what you, it's not just, let me Start again. It's not just avoiding a misrepresentation, it's correcting a false impression when that is made, correct?
I'm not sure if we'll agree on the definition of candor in that sense. Could you repeat that again, please?
Sure. Let me fill it out a little bit for you. Are you familiar with Michigan Rule Professional Conduct 3.3 involving candor to a tribunal?
Yes.
That requires that lawyers not only avoid misrepresentation directly by falsely stating something, but also requires lawyers to correct a false impression that might have been left by something that wasn't said. You agree with me on that, right?
I agree with the definition of the rule, yes.
Okay. Does the Wayne County Prosecutor's Office expect less candor than lawyers are required under 3.3?
No.
You agree with me that under Rule 3.8 of the Rules of Professional Conduct, in the comment, it describes prosecutors as ministers of justice.
Yes.
So you are aware of that, correct?
Yes.
You testified on direct examination that you were aware of no problems. That was your phrase, no problems, regarding Anna Bickerstaff, correct?
I'm trying to remember the rest of that question, but yes.
Okay, you agree with me that it would be a problem if you learned that she lied to Detective Kinney, an employee of the Wayne County Prosecutor's Office, correct?
If Ms. Bickerstaff lied to a detective?
Yes.
Is that what you're asking me?
Yes.
Yes, that would be an issue.
You agree with me that it would be a problem if Anna Bickerstaff lied to Chief James Bivens?
Yes, it would be a problem if she lied to Chief James Bivens.
You also agree with me there would be a problem if she lied to Prosecutor Worthy?
Yes.
And I assume it would be a problem if she lied to the Judicial Tenure Commission and its staff, correct?
Yes.
And it would be a problem if she lied to this master in these proceedings, correct?
Yes.
Would be a problem if she lied to a defense attorney?
Yes.
Mr. Muscat, am I correct that in addition to actively lying, that if a prosecutor in the Wayne County Prosecutor's Office knew of a false statement somebody else had made but not corrected, that would be a problem?
You know, those are highly subjective matters, but generally, based on your description of the ethical responsibilities, I agree with you, yes.
Mr. Muscat, you identified yourself, I believe, as a supervisor for Anna Bickerstaff, is that correct?
I'm not her direct supervisor. I'm the supervisor of her supervisor. I'm number 2 in the division, I guess.
And safe to say in 2019, she had a direct supervisor, correct?
Yes.
She had a supervisor, correct?
Yes.
Is there somebody above you? Is there a third tier of supervisors, or do we get to the prosecutor?
It goes from me to Chief Athena Syringas, and then to our Chief of Staff and to Prosecutor Worthy.
And you would agree with me that Anna Bickerstaff had been at the Wayne County Prosecutor's Office, well, not continually and every day, but consistently since 2011, correct?
Yes, and between internships and then eventually full-time employment, yes.
May I have just a moment, Your Honor?
Yes.
Mr. Muscat?
Yes, sir.
Thank you. Mr. Muscat, you mentioned in your direct examination that there came a time where Anna Bickerstaff came to see you to talk about her testimony in this matter, in these proceedings. Do you remember that?
No, I didn't say that she came to see me, and it wasn't during direct. I mentioned in the beginning that I talked to Ms. Bickerstaff on the phone, and the topic of her testimony came up.
So that conversation on the phone was after these proceedings had begun, correct?
Yes.
And it was after Anna Bickerstaff had testified, correct?
Yes.
When did you first become aware of the amended sequestration order in these proceedings?
It was after that, when counsel sent me a copy of it. I don't recall the date.
And you read those? You read the amended order, correct?
Yes, upon receipt, I did.
And is that, am I correct? That is what triggered you to contact Ms. Weingarten to tell her about the conversation that you had already had with Ms. Bickerstaff, correct?
No, I think when, I can't remember the exact sequence of events, but when Ms. Weingarten contacted me to testify in rebuttal in this case, I believe I mentioned that conversation, and then I received, right about the same time, then I received the orders. So I don't know, what I'm telling you is I don't know if I told her that before I received the order or after I received the order, but it was in a very close sequence. It was after the conversation with Ms. Bickerstaff, obviously.
Have you ever asked Ms. Bickerstaff why she violated the sequestration order in talking to you about her testimony?
At the time I spoke to Ms. Bickerstaff, I didn't believe that she was in violation of the sequestration order, so no, I didn't.
At the time, well, let me be clear here. At the time you spoke to her, you didn't know about the sequestration order, correct?
I did not know about the sequestration order. I had not received a copy of it at that time, no.
I want you to assume that Ms. Bickerstaff knew about the order, that she had been read the order the same way you were by the master, that at the conclusion of her testimony, she was told she was still under that order. So my question again to you is, did you ever have a conversation with Ms. Bickerstaff about her violation of the sequestration order?
I'm not sure it was a violation, counsel, in that regard. It was a fairly ministerial matter. I reported it to Ms. Weingarten, which I believe is my responsibility. It was about whether or not how to count second chairing a case or something to that effect. It was, I would not say something significant to the proceedings.
Mr. Muscat.
Yes, sir.
You've read the order now, right?
Yep. Yes, sir.
You've had it read to you, right?
Yes, sir.
It says, don't talk about your testimony, except to counsel for the parties, right?
Yes.
She spoke to you about her testimony, correct?
About that, about whether or not how to count or the second chairing of cases. Yes.
So I'm going to keep asking that same question until you answer it yes or no, now that you've had your little chance to say that. Could we have the question please reread?
I said yes, Mr. Campbell.
Okay, thank you. I have no further questions for this witness.
Thank you. Anything further, Ms. Weingarten?
Yes. In your communication with Ms. Bickerstaff over the phone, did she share with you that she may have testified to something incorrectly?
Yes, because of in the context of how many cases she's co-chaired or second chaired or something like that.
Did you give her any advice about what to do about that error?
If I remember correctly, I told her that I thought it was a ministerial or minor matter, but to talk with you about it, I believe.
And do you know if she did in fact talk to me about it?
No, I don't know if she talked to you.
No other questions.
Thank you. Mr. Campbell? You're muted.
Mr. Muscat, I just want to make sure the record's clear. Minuscule or not, the reason she brought it up to you is she felt that maybe she had made a misstatement or a false statement. Oh, that's too hard to call it. That she may have testified incorrectly about some facts, correct?
About that fact, yes, I think that's fair to say.
Okay, so the conversation was about her testimony, correct?
Yep, it was about that fact.
Thank you.
Thank you. Ms. Weingarten, anything further?
No.
Thank you. May this witness be excused.
Yes.
No objection.
All right, thank you. Mr. Muscat, we are excusing you at this time, so you may leave the meeting. You are still under the orders that I read to you initially until the proceeding has ended. Thank you.
Thank you.
Are there any additional rebuttal witnesses from the disciplinary council?
There are not.
All right, thank you. And any rebuttal witnesses, Mr. Campbell or?
Sir, rebuttal? No, Your Honor. I have no further witnesses to call.
All right, thank you. Counsel, at this time, I am ready to talk with you in a sidebar with respect to the information that you want to present about that proposed exhibit, disciplinary council exhibit 12. I think Ms. Weingarten, you indicated you have an additional argument. So I'll hear from counsel with respect to that. We'll do that in a sidebar room, and then we'll take a break and come back for your closing arguments.
Thank you. I do have one motion to make. I don't know that it needs to be decided before the closing arguments, but I'd like to make the motion before the closing arguments.
All right, let's go into the sidebar room at this point then. All right, I think we are all back here. We are going to take a 15-minute break at this time and come back at around 11:15. We will be doing a sidebar at that time, and I believe we will be ready for the closing arguments around 11:30, which will be live streamed. Council, anything further with respect to that?
No.
All right. Nothing. All right. Thank you. We'll take we will come back at 11:15 after this brief break. Thank you. All right, I believe at this time we are ready then to go into the closing arguments. And I will hear from the disciplinary counsel first, then from the respondent, and the final from the disciplinary counsel. Ms. Weingarten, we're ready whenever you are.
Okay. Your Honor, the facts of this case are not really in dispute. Judge Morrow's answers to the complaint, his answers to the request for comment letter, and the answer to the 28-day letter acknowledge most of the facts. Many of the facts are corroborated by more than one witness. Based on those facts, it is clear that Judge Morrow violated the Michigan Code of Judicial Conduct and the Michigan court rules. In count 1, he is charged with inappropriate use of sexually graphic language, and it involves what occurred between himself and Ms. Bickerstaff at the prosecution table. Ms. Bickerstaff asked the judge if she did better questioning the witnesses by not starting every sentence with the word and Judge Morrow said yes. But I'm going to come down there to talk to you because what I have to say could make you blush. We have a lot of evidence that that statement was said. Ms. Bickerstaff heard it, Mr. Curley heard it, and Judge Morrow admits making that statement. If a judge or any person tells a young woman, what I have to say could make you blush, he should think twice about saying whatever it is. But Judge Morrow didn't think twice. Instead, he came down and sat next to Ms. Bickerstaff in a chair with the arms touching her chair. He had the option of moving the chair away or moving it to another side of the table, but he didn't do that. Ms. Bickerstaff testified that their heads were a foot or a foot and a half apart. Judge Morrow kept the conversation private. He didn't invite defense counsel. He didn't speak loudly, and his eyes looked into Ms. Bickerstaff's eyes the whole time they spoke. He said the following things to her, which he admitted he said. When a man and a woman are romantically close, what does that lead to? So when a man and a woman are close, they start holding hands, rubbing elbows, kissing, foreplay, then that leads to sex? The cause and manner of death should be the climax of the medical examiner's testimony. You start with all the information from the report, all the testimony crescendos to the cause and manner of death, which is the sex of the testimony. You want to tease the jury with the details of the examination. The climax of the testimony from the medical examiner should be the cause and manner of death. Ms. Bickerstaff also testified that Judge Morrow said the following things to her. Would you want foreplay before or after sex? The climax of sex is akin to getting the medical examiner to state the cause and manner of death after getting the details of the examination of the body. Some of the content of their conversation is corroborated by other witnesses too. Lieutenant Derek Griffin, who was the officer in charge of the case, overheard Judge Morrow making sexual analogies and overheard him describing a sex act as leading to a crescendo. He felt the conversation was not professional and the courtroom was not the place to have that conversation. He didn't intervene because he didn't think he had the authority to overrule a judge in the judge's own courtroom. Ms. Chaffone came back from the restroom and overheard Judge Morrow tell Ms. Bickerstaff that the cause and manner of death are like the climax. So determining the facts are easy in this account. Paragraph 17 in the amended complaint alleges that Judge Morrow violated 4 canons by doing these acts. Canon 1, which requires a judge should personally observe high standards of conduct. Canons 2B and 3A14, which require that a judge treat every person with courtesy and respect. Canon 3A3, which requires that a judge be dignified and courteous to lawyers. Judge Morrow's statements to Ms. Bickerstaff, especially in the context of how intimately they were seated, how close their heads were to one another's, and the eye contact they had, clearly his conduct violated each of these canons. His statements were completely unnecessary to make the point he wanted to make. There was no reason for him to explain his theory of direct examination in this particular way, other than to inject explicit sex into this conversation with this young woman. This was not a high standard of conduct. It was very discourteous, very disrespectful, and very undignified. In count 2, Judge Morrow was charged with the same thing, inappropriate use of sexually graphic language, and this relates to what occurred in chambers. Judge Morrow talked to Ms. Chiffone about her own personal biases and her experiences with non-traditional sex. He laughed or joked about the defendant's testimony and the size of the defendant's penis, which Judge Morrow called a dick, according to Ms. Bickerstaff, and what he was working with, according to Ms. Chiffone. Mr. Noakes recalls that the judge laughed at the defendant's testimony and characterized it as an exaggeration of his sexual prowess. Judge Morrow used the word fuck during the conversation to describe what the defendant had done to the now deceased victim. The only reason to use that word in that context is for shock value. He criticized Ms. Chiffone's voir dire, and to illustrate the point, he created his own voir dire question. He said, "If I want to have sex with a woman on the first date, how would I figure that out? I wouldn't ask if she wants a family or children or what she does. I would ask her, have you had sex on a first date before? Would you sleep with me on a first date?" We know that Judge Morrow said this for multiple reasons. Ms. Bickerstaff and Ms. Chiffone heard him say that. Judge Morrow admitted that he said or probably said of some of them, such as the word fucked. And he admitted that he gave a voir dire question similar to the one that I just repeated. Mr. Noakes corroborated Ms. Chiffone and or Ms. Bickerstaff's testimony about what occurred in chambers, and he provided testimony that contradicted Judge Morrow's answers to the complaint. The prosecutor said that Judge Morrow told Ms. Chiffone, "Most people do not interpret non-traditional sex the way she does." Judge Morrow denies saying that, but Mr. Noakes testified that Judge Morrow did say that. The prosecutor said Judge Morrow joked or laughed about the defendant's testimony. And Judge Morrow in his answer said, though he's not sure he laughed, he said he's not sure he laughed, but Mr. Noakes said clearly, Judge Morrow may have laughed about defendant's exaggeration of his sexual prowess. Ms. Chiffone and Ms. Bickerstaff testified that Judge Morrow said, "How big does this guy think he is?" referring to the defendant's penis. Judge Morrow didn't answer that question, but Mr. Noakes said, Judge Morrow said it. The prosecutors and Mr. Noakes say that Judge Morrow provided Ms. Chiffone with that sexual voir dire question. Judge Morrow answered that he does not recall the exact words, but he admits he used a similar example. In short, everything Ms. Bickerstaff and Ms. Chiffone testified to was corroborated by each other's testimony and also mostly by Mr. Noakes' testimony and Judge Morrow's answers. To the extent that some of the exhibits contain Judge Morrow's denials, that he did a couple of the things that Ms. Chiffone and Ms. Bickerstaff say he did, it is important to keep in mind that he did not give that testimony at this hearing, and he did not give those denials here, where he could be cross-examined about it. Paragraph 28 of the amended complaint alleges the same violations of the canons as in count 1. As in count 1, Judge Morrow clearly violated each of the canons in his chambers that day. His comments in chambers were not of a high standard of conduct. They were very disrespectful, very discourteous, and very undignified. During the hearing, Mr. Campbell tried to establish that the two women did not appear visibly upset or uncomfortable with the things Judge Morrow said about sex and with his language. He also tried to establish that the women did not try to stop Judge Morrow from talking to them that way verbally or by physically removing themselves from the situations. I cannot say this strongly enough. Ms. Bickerstaff and Ms. Chiffone had no power in this situation. Judge Morrow had all the power. He's a judge. The women were well aware that he had contempt power, and he had the ability to grant the defense motion for directed verdict and dismiss their case, which they cared deeply about. These are young lawyers, as opposed to the character witnesses who testified on behalf of Judge Morrow, who have been his friends for years and lawyers for over 40 years. They testified they would simply excuse themselves from an in-chambers discussion that they didn't want to be a part of. But these young women couldn't do that. These young women were taught to take whatever a judge dishes out, and in the end, to say thank you. no matter what. Any person who has been a lawyer, and especially a young lawyer, knows the aura of authority that judges carry. There is a reason the canons protect lawyers from judges and not the other way around. In addition, it doesn't even matter whether or not these women were upset or tried to get away from the situation. The things Judge Morrow said were objectively disrespectful, discourteous, and undignified, even if the women didn't object at all. Count 3 of the complaint charges that Judge Morrow violated the Michigan court rules and the canons, this time by talking with the female attorneys about their height and weight and about Ms. Bickerstaff's muscle mass. Judge Morrow's answer to the request for comment, which is Exhibit 2, admits to everything the women testified to, except for one fact, whether he was overtly eyeing both of their bodies. He agreed with the lawyers that he asked Ms. Chaffone how tall she was and how much she weighed. He agreed that he asked Ms. Bickerstaff if she weighs 115 pounds. And he agrees, he said to Ms. Bickerstaff, well, I haven't assessed your body or your muscle mass yet. The only question of fact Your Honor needs to decide is whether Judge Morrow also overtly eyed their bodies when he did this. We know he did for the following reasons. Ms. Chaffone and Ms. Bickerstaff saw him do so. Both women were able to show you with their eyes what Judge Morrow did by looking them up and down their bodies with his eyes, and they demonstrated that for you. Neither one of these women has a reason to make that up. A woman knows when she's been overtly eyed. Ms. Bickerstaff responded to Judge Morrow's guess about her weight, and Judge Morrow said, well, I haven't assessed your body mass yet, or your muscle mass yet. The answer implies that he had already assessed their height and weight. The only way to do that is to look at their bodies. And the most likely time he did this was during the conversation he had with both of them about their height and weight. It's the same conversation in which the women say he eyed their bodies. So the evidence is clear that Judge Morrow did overtly eye their bodies. By doing these things, Judge Morrow violated the Michigan court rules and the canons set forth in paragraph 34 of the complaint. Michigan Court Rule 9.202B1D forbids treating a person discourteously because of the person's gender. There can be no doubt that Judge Morrow did that. His conduct also violated the canons of the Michigan Code of Judicial Conduct. Canon 2A, which states a judge must avoid all impropriety or appearance of impropriety. Canons 2B and 3A14, which require a judge to treat every person with courtesy and respect. And Canon 3A3, which requires a judge to be dignified and courteous to lawyers. Looking two women who he barely knew up and down while talking about their height and weight, announcing his plans to assess Ms. Bickerstaff's muscle mass is creepy, and it's certainly discourteous. This is especially so after Ms. Chaffone reminded Judge Morrow of what everyone knows. It is not polite to ask a woman her weight. But he still continued the discussion by asking Ms. Bickerstaff about her weight. It was also especially discourteous for him to look their bodies up and down as he made those statements. Finally, Your Honor must decide whether the conduct charged in counts 1 through 3 was a persistent failure to treat Ms. Bickerstaff and Ms. Chaffone courteously because they were women in violation of MCR 9.202B1C. The evidence showed that he violated the court rule. Over a 24-hour period between 2:57 p.m. on June 11th and whenever he released the jury at the end of the day on June 12th, Judge Morrow repeatedly was discourteous to the women in ways that were sexually charged. He treated Ms. Bickerstaff discourteously 3 times and Ms. Chaffone discourteously twice. Your Honor signed an order on November 12th of 2020, allowing into evidence Exhibits 10 and 11, the letter to Judge Morrow from the Judicial Tenure Commission, and a letter to Judge Morrow from the State Court Administrative Office. You ruled that the exhibits are admissible, quote, for the limited purposes of demonstrating guidance regarding inappropriate sexual language that respondent had previously received, unquote. Judge Morrow's lawyers cannot legitimately argue that Judge Morrow didn't know his words would be undignified, discourteous, disrespectful, or embarrassing to Ms. Bickerstaff or Ms. Chaffone. He was informed that his conduct in the past was inappropriate, and he was educated on how to conduct himself in the future. In Exhibit 10, the Judicial Tenure Commission informed Judge Morrow, quote, "The commission cautions you against engaging in conversations with court staff which are of a personal or intimate nature and which may be regarded as offensive or embarrassing," unquote. In Exhibit 11, the State Court Administrative Office informed Judge Morrow, quote, "It is inappropriate to discuss matters of a personal nature with staff unless that individual is an acquaintance or friend," unquote. The State Court Administrator's Office informed Judge Morrow that he should, quote, "refrain from initiating or participating in inappropriate conversations with staff regarding topics of a personal nature," unquote. There can be no legitimate argument that Judge Morrow didn't know or didn't realize that analogizing to foreplay, sexual teasing, climax, crescendos, and sex would be inappropriate, offensive, or embarrassing to the two women. There can also be no legitimate argument that Judge Morrow didn't realize that the things he said to them in chambers were inappropriate, offensive, or embarrassing. Finally, there can be no legitimate argument that Judge Morrow didn't realize that when he spoke with Ms. Bickerstaff and Ms. Chaffone about their height, weight, and Ms. Bickerstaff's muscle mass, that he was discussing matters of a personal nature. Because Judge Morrow had prior knowledge, the only conclusion that can be drawn is that he ignored this prior instruction and chose his words and analogies intentionally. The fact that Judge Morrow had a painting of Bill Cosby on the wall of his courtroom after Cosby had been convicted of sex crimes involving women that he drugged and assaulted speaks volumes about how Judge Morrow does not respect women, is not courteous to women, and is not dignified to women. Judge Morrow's inability to recognize how a woman feels when a judge in a position of power says sexually inappropriate things to her, coupled with his decision to hang a picture of a convicted sex offender on the wall of his felony trial courtroom, where sex crimes cases are tried and sex crime victims can see it, shows that he is out of touch with the effect of his words and conduct. Judge Widgeon, you may have noticed that Mr. Campbell's and Ms. Jacobs' focus during the great majority of this hearing had nothing to do with the statements Judge Morrow made to the prosecutors that are charged with the complaint. And I'm sure it goes without saying, but to be clear, I'm going to list all the things that this case is not about. This case is not about whether Judge Morrow is friendly with jurors. It is not about whether he was polite during the trial, whether he gave correct feedback to the lawyers, or whether he understood the rules of evidence or the court rules. It is not about whether the prosecutors did or did not handle the 404B evidence properly. It is not about why the Matthews case was so old, the quality of Ms. Chaffone's voir dire, or whether her opening statement was correct or whether her closing argument was correct. It was not about whether Ms. Chaffone was a good mentor. It was not about how many questions Ms. Bickerstaff began with the word "and," or the sufficiency of the evidence to convict Mr. Matthews. This case was not about why the Matthews case was transferred to a different judge, nor which judge it was transferred to. It is not about whether Mr. Bivens or Ms. Kitty were the ones who incorrectly recorded that Ms. Bickerstaff thought Judge Morrow was hitting on her. It is not even about whether Ms. Bickerstaff actually thought Judge Morrow was hitting on her. Each of these things that was explored by Mr. Campbell and Ms. Jacobs during the hearing is a red herring dragged across the path in an effort to obscure the trail. The burden of proof in a judicial disciplinary proceedings is preponderance of the evidence. The evidence has proven the allegations in the complaint by much more than a preponderance of evidence, and we urge you to so find. Thank you.
Thank you, Mr. Campbell. Anytime you're ready.
Thank you, Your Honor. I'm going to say a few words until my owl catches me. I see it has. Judge, I want to start out by noting that it is the Judicial Tenure Commission who decided not to call my client to testify. They have that right to do in these proceedings. They didn't call him to testify. They didn't make their case, so why would he testify in mine? The JTC's theory is that Judge Morrow engaged in misconduct because he spoke words that they declare to be wrong, words they deem to be taboo for a judge to say. The proofs show that the words spoken by Judge Morrow were right and proper for the situations as they existed, and the words were properly used for the purposes intended by Judge Morrow. The words were right, they just went into the wrong ears. At worst, that is what could be said. Judge Morrow used the right words, but they found the wrong ears. That is not misconduct. In contrast to Judge Morrow's conduct, the right words in the wrong ears, the JTC's case is based on wrong words, lies, being placed into the quote unquote right ears. Folks waiting to hear an accusation against Judge Morrow. Their case is based on the wrong based on the wrong words being placed in the quote unquote right ears. This case arises because Anna Bickerstaff used the wrong words Judge Morrow was hitting on me, or at best, allowed the wrong words to be perpetuated when she failed to correct the Bivens memo. She knew the wrong words would go to the right ears, the ears of folks who have long battled with Judge Morrow and who do not like him. Prosecutor Worthy and others forced the motion to disqualify. They presented this grievance, and the JTC was all too willing to bring this case, even in the midst of a pandemic. Those actors were motivated by the Bivens memo. Whether Anna Bickerstaff said the words that Chief Bivens testified to here today, or allowed them to be produced as if she had said them, it resulted in the wrong words reaching the quote unquote right ears. Through our character witnesses, we have established Judge Morrow's history and reputation of concern and care for everyone in the court process. He treats people with courtesy and respect. True to his history, his professional treatment of others is on display in the court transcripts and is replete throughout the record of this case. It is found in the conversations with the jurors during voir dire. It's also found, and you may recall this, the witness with the t-shirt with the profanity written across it, the same word that Ms. Chaffone and Ms. Bickerstaff speak of being shocked to hear in its proper context later in the case. They present a witness on the stand wearing a t-shirt with that word used in its obscene meaning, in its profane meaning. Who protects her? Judge Morrow, as we pointed out in the transcript. We highlighted some, but not all, of the kindness in his phrases and the calmness in his tone during the interruptions and admonishments to counsel, resolving the objections and addressing objectionable conduct throughout the trial. Yes, the JTC cites the two letters in the early 2000s. As you must know, because you read them, they're really one letter from two different sources. But there was no testimony or evidence ever taken in that matter. It is folks who never liked him saying things that aren't true. Recall only, if you need to, Joan Kennedy Hughes's testimony. Extraordinary. Sitting at home, getting a call getting a job offer at Wayne County. One catch. You got to tell us something bad about Judge Morrow. He inspires great affection and respect, but he also inspires fierce opposition. Some people just do. He does. As Taylor Swift says, haters gonna hate. As you have heard, Judge Morrow has been on the bench in the busiest criminal court in this state, hearing exclusively criminal matters for almost 30 years. And a letter from more than 15 years ago is all they have. Exhibit I, in contrast, look at that. That's the proceeding before Judge Michael Hathaway. Read that transcript of the 404B hearing, the redo that the prosecutors got as a result of their conduct in this case. Witness his, meaning Judge Hathaway's, derision and taunting of the defendant that drips from those pages. And you'll spot more evidence of ill behavior there than the JTC has conjured up over 3 decades of Judge Morrow being on the bench, let alone his 68 years on this earth. Judge Hathaway is a former member of the Judicial Tenure Commission. The JTC charges key on 3 conversations. One, the chat with Anna Bickerstaff. That's Ashley Chiffon's phrasing. They were chatting. The discussions in chambers and the guesses about height and weight. Taking the table talk first, Judge Morrow's words were right in his conversation at the table with Ms. Bickerstaff and with the detective immediately next to her, also seated there. His hypothetical taught the lesson he wanted to impart. It taught Anna that the cause and manner of death should be the last questions testified to by a medical examiner. She acknowledged when she testified, Ms. Bickerstaff testified, that she learned that point from his statement. Will use it going forward. Judge Morrow had no idea that his analogy would be taken in the manner testified to during these proceedings. And Ms. Bickerstaff admits that she gave him no hint or cue during their chat that she found the subject insensitive or inappropriate. There was back and forth during that conversation, even in the telling of Ms. Bickerstaff. Just as her head was the same distance from his, as her chair was the same distance from his, as her eyes were looking at him and continued to look at him through the conversation. This was merely a chat, as described by Ashley Chiffon, and Anna Bickerstaff participated in that chat. Likewise, concerning the in-chambers conversation, Judge Morrow's critique of the DNA evidence and comments related to doing a better voir dire were proper, and his words were right. The term that they have alleged is a synonym for intercourse. There is no allegation that he used the term as an obscenity. That is what was on the t-shirt. That's the testimony of Mr. Noakes. You will see when you review the exhibits in this matter that Ashley Chiffon used that same term that Judge Morrow used that was on the shirt twice during her closing argument at page 57, lines 24 and 25 of the transcript of her closing argument. She uses it in a manner that's understood to be profane. He uses it as simply a synonym for intercourse. The judge's conduct is at worst simply a matter of the right words heard by the wrong ears. An overestimating of a hearer's maturity or an insensitivity to their immaturity does not rise to the level of judicial misconduct. Using the right words, even if misunderstood, is not a violation. We'll have a chance to brief and go through the cases in greater detail, but you're going to see the In re Hocking 451 Mich 1 1996, where the Supreme Court draws exactly that distinction. Words that may be insensitive are not a violation and do not constitute misconduct. The other cases that they'll cite, if they cite any at all, will be cases where profanity is used, where swear words are directed at somebody. That's not this case. So let me explain further what I mean when I say that JTC's case is based on the wrong words going into the quote unquote right ears. This case was cast as Judge Morrow hitting on Anna Bickerstaff. Recall that the JTC was not told by Anna Bickerstaff that the Bivens memo was inaccurate until September 29th, 2020. That's Exhibit L. The JTC filed this case in early August, nearly 2 months before they learned that the Bivens memo was unreliable. Chief Bivens' memo plainly states that Judge Morrow was hitting on Anna Bickerstaff. And we now know it's because that's what he was told by Anna Bickerstaff. It is that memo that Prosecutor Worthy read. She certainly also heard about it. Chief Bivens testified to meeting with her. And how could you not imagine that she also repeated that same information? Without any doubt, it is what the JTC obviously relied on because they had the Bivens memo. Yet that memo, that statement, is untrue. Judge Morrow did not hit on Anna Bickerstaff. Those words in the Bivens memo are clearly the wrong words. But they reached the right ears for getting a disqualification, in fact, multiple disqualifications without hearings. Is there any way those wrong words didn't get to Chief Judge Kinney? And they met the right ears for the purpose of pursuing a JTC investigation. Recall Anna Bickerstaff and Ashley Chaffone both said they had never even heard of the JTC and that they were merely presented with completed forms to sign. The direct influence of the Bivens memo is seen plainly in their allegations in paragraph 8 and paragraph 33 of the complaint. And while they have made some small scrivener changes to dates and numbers, they have never backed away from what they alleged based on the Bivens memo. They thought Anna was going to come in here, Anna Bickerstaff was going to come in here and say, oh, I had never seen the Bivens memo before. I didn't know. Focusing on paragraph 33 for a moment, both Ms. Bickerstaff and Ms. Chaffone testified that they did not use the term overtly eyed in any of their conversations with the JTC or anybody else. They both admit that they did not author those words or suggest them to the JTC. They both concede that they did not see or discuss the phrase overtly eyed, which is manufactured by the JTC in paragraph 33, until after the JTC complaint was filed. It is a fabricated byproduct of the wrong words contained in the Bivens memo. Those wrong words have reached the right ears for bringing this case. Ears of folks who do not like Judge Morrow and were waiting to hear and assume the worst. The ears of the bosses at Wayne County and the ears of the JTC. Should Judge Morrow have been more careful in communicating the concepts and ideas, whether about cross-examination, voir dire, or the DNA evidence? And should he have been more concerned about his words or how his words would be presented to others? If that is his human error, it is certainly not judicial misconduct. But compare this potential error in talking to folks who were not as ready for his examples as they appeared to be, to the intentional conduct by Anna Bickerstaff and Ashley Chaffone. Ms. Bickerstaff made up or failed to correct false, it's not fair, damning information against Judge Morrow. And Ms. Chaffone stood by and let it happen. Let's be clear. There is no difference in terms of how reprehensible the conduct is between saying to Chief Bivens that Judge Morrow hit on her and failing to correct that statement as testified to by Ms. Bickerstaff. None. The act of causing or allowing through non-correction a statement such as was known to exist in the Bivens memo is abhorrent. It is not a misjudgment. It is not a mistake. It is an injustice. Plain and simple. And it is that injustice which the JTC builds the foundation of this case on. Hell, it is their entire case. The ease with which these two prosecutors, Bickerstaff and Chaffone, these ministers of justice, slough off any responsibility for their conduct and how this all came about speaks volumes about their lack of trustworthiness and their lack of credibility. These are echoes of Victoria Price and Ruby Bates, accusers in the Scottsboro Boys trial, where Judge Horton famously wrote that history, sacred and profane, recorded that some witnesses, for selfish reasons, make false accusations. It's also an echo of Carolyn Bryant, who would later admit that part's not true when asked about her testimony that Emmett Till had physically abused her, when in truth he had merely said, "Bye, baby," as he left the store where she was working. Lies led to real lynchings in those matters. It is not progress that they are merely high-tech now. Ms. Bickerstaff's and Ms. Chaffone are too comfortable with their lack of candor and too familiar with their fraud. Ms. Chaffone spoke of the magnitude of her cases as if they would and often do justify the errors we have demonstrated to you that she made in this case. Let's talk about content versus intent. The JTC's case is solely about content of his statements. There is no evidence now that the Bivens memo is discredited of any ill intent. Let's look closely at what has been proven about the content through the evidence. First, the conversation at the table. As context, Anna Bickerstaff had been politely and directly reminded of her overuse of "and" in front of her questions. It was a problem. She did it nearly at a 70% clip through the first three witnesses that she took testimony from. Even as Anna Bickerstaff admits, she had a significant problem. We detailed it, and there can be no doubt that 70% rate of beginning questions with the word "and" is grating. Despite having the issue raised to her, the issue being understood by her, her appreciating what had been told to her, it had no impact on her questioning of the very next witness. In fact, she actually thought she had done a good job when she asked the judge at the end, did I do good? And his comment kindly was, well, better, but I have another tip. So Judge Morrow tried another tack. He used an instructional technique that is not new, that is appropriate in a mature conversation, and despite everything else, was undeniably successful. This is no small feat when you consider that his direct attempt at instruction had produced such a miserable result in trying to affect the use of the word and. He employed a hypothetical about sex to explain that the cause and manner of death should be the last two questions to the medical examiner. Ms. Bickerstaff took an active part and participated in what Ms. Chiffone described as chatting. Ms. Bickerstaff did not withdraw or give any sign of uncomfortableness. None. None to Ashley Chiffone, none to Detective Griffin, none to Joseph Curley, and most importantly, none to Judge Morrow. Sex is a valid and often used subject for instruction among mature people. I asked Anna Bickerstaff if she knew the name Brian Garner. He's an appellate guru. He writes in the ABA Journal, regular articles there on a monthly basis. He's an author of a number of books. It just so happens that a couple of years ago, he gave me a copy of his best-selling book, The Winning Brief. Long story, and it ends with me admitting that I never really read it. But it was brought to my attention, all the folks on YouTube, it was brought to my attention in preparing for this case when an associate was in my office, saw the book on my shelf, and said, you know, that book is the reason I never use footnotes. Intrigued, I asked her why that book is the reason she doesn't use footnotes. She explained that while she had read the whole book, it was one chapter that was particularly impressive to her. And in that chapter, Brian Garner taught, quote, having to read footnotes is like having to go downstairs and answer the doorbell while you were upstairs having sex. The associate admitted to me that she could not remember what was in any of the other chapters, before or after, but this analogy taught her to never use a footnote again. Former Chief Justice of the Michigan Supreme Court, Robert Young, in 2004, described the common law using the image of a drunken, quote, a drunken, toothless, ancient relative, end quote. A person he would go on in the same piece and describe as grandpa, who he placed naked in the midst of a garden party, splayed prominently before the guests on a settee. You can't unsee that once you've read it. You can't help but understand how he feels about the common law after you read it. A story about sex or nudity can instruct lawyers about how to practice. Sex is not taboo when discussing lawyering. Judge Morrow communicated that the last two questions should be about the cause and death, a point that is not debatable. That is sound advice. Like not saying and in front of the vast majority of your questions. Did Judge Morrow misjudge his audience? Was it the right words, but the wrong ears? Seems so at this point. Being wrong about whether his words would be fully understood is not judicial misconduct. It never has been, and it should not become so now. The advice about the voir dire in chambers, let's talk about that. It is no different. Importantly, the proposed question to the prospective date was not the first or only example Judge Morrow gave. He had given examples during the pre-voir dire that are in the transcript that we went through. He had challenged Ashley Chiffone during her voir dire in the transcript to address the question about what she really wanted to learn during voir dire. Even the testimony about the back and forth in chambers, conceded by Ms. Chiffone and confirmed by Mr. Noakes, about the voir dire, shows that Judge Morrow used the hypothetical questions to his made-up prospective date as punctuation of a point he had been trying to communicate since the beginning of trial. Ask a juror a question that you want to know and ask the questions that get you the answers you can use. While we are on the conversations in chambers, the arguments in chambers, as they have been described, and this is an important point. Counsel in her closing suggests that there is a unanimity between Ms. Chiffone and Ms. Bickerstaff on their recollections and their memos. That's not true. For example, Ms. Bickerstaff says in her memo that the judge yelled. In her affidavit, she says that he said it very loudly. Ms. Chiffone says in her memo that the judge raised his voice a little bit. In her affidavit, she says that he raised his voice a bit. One example, and I'll go through several, of differences that are significant between what Ms. Chiffone recalls and what Ms. Bickerstaff recalls. There are several more points, though, to highlight right now about the in-chambers discussion. The first item back in chambers was the legal issue of the standard in the directed verdict motion. Ms. Chiffone admits that Judge Morrow spared taking her to task on that issue in the courtroom. Remember, Judge, there are all these various and sundry assistant prosecutors walking in and around this case in that courtroom. He spares her from their eyes and ears when he invites her opposing counsel, Mr. Noakes, and Ms. Bickerstaff back to his office, back to the chambers. There is no doubt that she misstated the standard in her argument. The judge, though, doesn't just give her a book, doesn't just take the moment to instruct her, hey, you were wrong. He gives both counsel a book, court rules, both counsel, to go through the rules together. Ms. Chiffone testifies that her focus from that point on is the part of the rule that states that a judge can dismiss a motion for directed verdict at any time. Now, Ms. Chiffone also testified she's done all these scores and hundreds of trials, most of them murder trials, now exclusively murder trials. And she's never looked at MCR 6.419. This is the first time. She argues a directed verdict motion in every case she tries. And this time is the first time she bothers or is put in a position to read what that rule actually says. And then when she reads it, she doesn't read it for the right purpose. Of course, the judge, any judge, has a right to issue the directed verdict. That's what the rule says. But the rule also says that the evidence has to be looked at as if it was enough to convict. That is the point. Judge Mr. Noakes, William Noakes, recalls more accurately that the exercise in chambers was about an education on what the proper standard was. So there's not only disagreements between Ms. Chaffone and Ms. Bickerstaff, there's also disagreements between what they say and what Mr. Noakes does. During the discussion of the DNA evidence, the JTC charges that Judge Morrow made improper remarks about the defendant, charging him with demeaning the defendant. They rely solely on Anna Bickerstaff for this. The JTC adopt her version and reject the versions provided both by Ms. Chaffone and by Mr. Noakes. Anna presents the comments without any context. She lists them in her memo and in her affidavit as non sequiturs, apropos of nothing, as if they just came out of the ether. But in her memo and during her testimony, Ashley Chaffone concedes at least some sort of context. Rather than punchlines, she recalls the statements as challenges, hyperbole, directed as questions to her when they were arguing over the significance, if any, of the DNA evidence. Specifically, Ms. Chaffone recalls that the judge said, oh, so he's claiming that what he's working with will cause a miscarriage, okay. And she provides the context as being a response to a position she took. It is him challenging her position. These are not jokes aimed at the defendant. They are challenges by Judge Morrow to Ms. Chaffone's position. As Mr. Noakes recalled, more credibly than either of the other two witnesses, there were statements that highlighted the defendant's exaggerations during his own testimony. The best evidence of whether Judge Morrow mistreated the defendant is that the defense attorney was there and did not react or take those statements in that vein at all, and still doesn't take them in that vein. Given the record of how they tried this case, you cannot say that Ms. Chaffone or Ms. Bickerstaff are in any way the angels of Mr. Matthews. So more words about the disagreements between Ms. Chaffone and Ms. Bickerstaff on the facts. Another example of where the JTC follows Ms. Bickerstaff and not Ms. Chaffone is the wording of what Judge Morrow said when he came down from the bench. The JTC charges that he said his statements would, not could, as they mentioned in their closing argument, but their charge at paragraph 6 is would make Anna blush. But Ms. Chaffone recalls that Ms. Bickerstaff told her that Judge Morrow said he would come down from the bench because what he wanted to say might make her blush. That's also in Exhibit 12 as part of the recollections that are recorded by Chief Bivens and Detective Kinney. Might make her blush. A very significant difference. One suggests the purpose, other suggests a concern. So one suggests the purpose is to embarrass you. The second is a concern to not embarrass you. Ms. Chaffone is more credible on this point. Her only source for the information is Ms. Bickerstaff. It makes sense that, like so much else in these events, it's Ms. Bickerstaff who, since she originally told her story, has twisted the events and the circumstances to be worse than they really were. Some considerations on the testimony of Mr. Noakes. The complainants treat him like he was not there. The JTC treats him like he does not matter, literally. He was in the chambers. He is what we used to call a raised jest eyewitness to the events that they have charged. And the JTC does not even call him to testify. They are not interested in what happened. They are interested in hearing what they have read in the reports, even if these reports are the wrong words. Mr. Noakes testified to a conversation covering several topics between counsel and Judge Morrow. In his telling, he is as much a part of the conversation as Ms. Chaffone. The complainants do not involve him at all in their retelling. They do not regard him at all in their stories. It was just a conversation between Ms. Chaffone and Judge Morrow, and mostly a soliloquy by Judge Morrow, they say. A 2-hour monologue. That is simply not credible. Compare with Mr. Noakes, who recalled that his performance in the voir dire and related to the DNA were also critiqued and criticized. That makes more sense. That's reliable. Lastly, while in chambers, the JTC alleges Judge Morrow used the wrong word for intercourse during the DNA arguments in chambers. Ms. Chaffone describes that scene as one where Judge Morrow is frustrated. Look at her testimony at page 57 of these proceedings. Yet she presses on in arguing with the judge. You will see in the white transcript that they have admitted, Exhibit 16, where Judge Morrow is frustrated by the prosecutor's conduct, which appears to be designed to poke him, interruptions, and other nonsense. And he responds by adjourning the motion and keeps his cool. Here, Ms. Chaffone says in her testimony that she recognized that he was getting more and more frustrated in their discussions. Quoted page 57 in part, after we had kind of going back and forth about the issue of DNA, he was getting more frustrated. And so it kind of, at that point, he then made his quote. Recall, she was defending the use of DNA experts and testimony about rape kits in a case where there was no criminal sexual conduct charge. And the DNA did not show the defendant strangled the victim. As testified by Mr. Noakes, there was none of the defendant's DNA on the throat where the human hands were used to strangle the victim. So the DNA evidence only showed that they had intercourse, a fact that was admitted by the defendant. In fact, admitted back in 2003, and that admission was used during the trial. And then, of course, he testified as well. Judge Morrow's comment on the DNA did not show anything beyond the established fact that was admitted by defendant. Was not improper, nor was it improperly said. Maybe, owing to frustration, he used a synonym for sex that but for the frustration, he would not have used. And we have allowed for that in our answer. Even if he did, it is used in the right sense. That is, to mean intercourse. It was not used as an obscenity. The word is not a taboo. No one in the room took it to mean anything but intercourse. When you look at the charges that come in concerning the chamber discussions, there are 3 witnesses to Judge Morrow's statements. Not surprisingly, they really don't agree on what precisely was said and what exact words were used. You know that Anna Bickerstaff has lied. Her written statements and her testimony here is not surprisingly the most aggressive and the least trustworthy of what happened in chambers. Ms. Chaffone gives some context, but the best recollection of the events and statements is that of William Noakes. What Mr. Noakes, a firsthand, only unbiased witness to these statements, cannot confirm, you should reject as not proven. Anna's false statements do not end with the Bivens memo. She says in this matter that she did not see the statement prepared by Detective Kinney. In these proceedings, Anna says she was not asked to approve the information in the Bivens memo. Moreover, Ms. Bickerstaff gave false information to Ms. Weingarten. I do want to take a moment to talk about that. Judge, can you tell me how much time I have left?
Yes, one moment. You have about 7 minutes left.
Thank you. Exhibits L and M are admitted. Ms. Weingarten provided a memo about Anna Bickerstaff's review of the Bivens memo pre-trial. You've seen Ms. Weingarten, and she is nothing if not thorough and professional. I have no doubt that her testimony would have been as we have agreed to accept as stipulated. But there can be no doubt that although she may not be able to recall in her mind now what was said, she recorded accurately what was said. She would not have made a mistake, certainly not one as significant as misstating whether Ms. Bickerstaff had said she had never seen the Bivens memo. There's a stipulation in place. Part of the stipulation is that she prepared a memo for me. That memo is now in evidence. Again, that memo to me is provided 2 days after she spoke with Anna Bickerstaff. She records in the stipulation that she made a separate memo for herself, work product. But if that memo said anything different than what she provided me as exculpatory information, we would know that. It is trustworthy that Anna Bickerstaff told Ms. Weingarten that she had never seen the Bivens memo until she was provided it. Ms. Weingarten's memo produced an exculpatory statement, one that gutted the main theme of their prosecution, that there was a sexual purpose behind the statements. The memo was made 2 days after the interview. You can imagine the consideration and care taken in producing it to me. It was an act of commendable professionalism and ethical responsibility, but it was not done willy-nilly, the opposite. And as much as I appreciate it having been done, it is clear from the questioning of Ashley Chaffone that the JTC knew as this case began that Anna Bickerstaff had said something to Ashley Chaffone about the error in the report way back in June of 2019. That information was not related to me, was first disclosed on this record. Make no mistake, as professional as the JTC staff is, they are out to win this case. They have pled it in a manner that they want to win this case. They have tried it to win at great cost if necessary. They have pulled out unsubstantiated letters from the early 2000s. They've talked about armpit hair. They have asked and clearly prepared Anna Bickerstaff about nightmares. Really, nightmares, Judge. You do not need to be Sigmund Freud to know that what's really bothering Anna Bickerstaff is the lies that she told. They have elicited from Ms. Bickerstaff and Ms. Chaffone testimony that they were concerned about the fact that it was their word against the judges. The implication is unmistakable. Judge Morrow, they present, is a liar. He's the kind of person who would be a liar, deceitful, and probably vengeful. He would be desperate to avoid any responsibility, even if it meant demeaning the judiciary of the office he has sworn to uphold. This from two women who would create false information, who would leave uncorrected, deceitful, damnable lies, or feign ignorance to avoid having to expose them. That's the testimony that JTC produces. The JTC elicited from the testimony that their alleged fears, knowing that Anna would allow the false and damning statements to fester and grow. We learned from Chief Bivens, she actually planted them. Their words against him. That is all they had, so they said. Did you imagine their words would be so completely made up? What is Judge Morrow's history and the track record on candor? Let's review his history with the JTC. They sent him a letter in 2005, but there's no mention of candor issues, none. He had been a judge for over 10 years then, not even a whisper. You heard he was prosecuted by the JTC.
I object. There's been no testimony about anything said about his 2005 hearing from the JTC. That letter,
there's no 2005 hearing, it's the letter. And there, you did elicit testimony from some of the character witnesses about the findings of the Supreme Court in the 2013 case.
Judge, Your Honor made a ruling limiting the admissibility of the 2005 and 2004 letters for a specific purpose. The rest of the letter doesn't come in and is not relevant.
If the letters came in. And so I'm allowed to comment on the letter not involving candor issues.
I did have a limitation on what those would be used for. And Ms. Weingarten, your objection is that this is outside of that limitation?
Correct.
Mr. Campbell, any specific response?
The letters are in evidence, and the letters say what they say, and they don't say anything about candor issues.
All right, I'm going to sustain the objection. Continue, please, Mr. Campbell.
Thank you. You heard that Judge Morrow was prosecuted in 2013 on 10 cases. They didn't tell you there were 33 cases investigated, hundreds and hundreds of allegations. They did charge him just on the 10, but no charges of dishonesty and no findings. We're going to present you with Judge Sosnick's findings in that case, where his laudatory language towards Judge Morrow is significant. The ridiculous examples of impeachment offered by the JTC is telling of the fact that none of it involved any dishonesty.
Objection, Judge. Judge Sosnick's opinion is not in evidence.
First of all, I think you can take judicial notice of it because it's part of the Judicial Tenure Commission's record. That's number one. Number two, it's part of our affirmative defense. They point to the Michigan Supreme Court made a finding. We have an affirmative defense that says the Michigan Supreme Court is part of a process that is unconstitutional because the same people who prosecute my client are able to then take a look on appeal and put right back in what the masters kick out of those appeals.
Thank you. Any further objection?
Judge, that issue went to the Supreme Court and they rejected it.
Yeah, that's my point. That's my defense. They rejected it because it was not a fair, this is not a fair system.
Mr. Campbell, the objection is overruled. Continue, please.
May I ask, so that I know that I can finish up here for 4 more minutes in light of the objections?
I'm sorry. May you ask what?
For 4 minutes, so that I believe I can finish my closing in light of the objections in the back and forth.
All right. I will give, pardon?
So 4 minutes from now, I think I will be done.
All right. All right. So that will be 4 minutes. I think you'll be over by a couple of minutes, but that is not a problem. Continue.
JTC offered testimony from the 2 complainants that they feared that no one would believe them. It was presented to gain them sympathy, but it is pathetic when put into context. What Ashley Chaffone said when she was pressed a bit about what she was worried about and why the tears at various times in the telling, she said she is worried about, quote, being associated with stuff, end quote. Quote, being worried about what people would think, end quote. And then, quote, being worried about gossip. That's at page 78 of her testimony. Obviously, gossip is something to be worried about. They work there. They know how rampant gossip is. They would know that any false statement to prosecutor worthy would be gossip for the entire building at Frank Murphy. They both said that they were not concerned about their employer, but you cannot square either of that with their conduct. With their claim here that they did not worry for their employment, it does not square with their failure to correct the testimony. And here I do not let Ms. Chaffone off the hook. She was the last bastion against the false statement being published, circulated, and relied on. But clearly Ms. Bickerstaff is the most responsible. If they had no fears for their employer, then how can the false statement not have been corrected? Anna offers us no answer. Ms. Chaffone offers us that Detective Kinney was intimidating. That's in stark contrast with Detective Kinney's personage when she testified. It is not believable. The most obvious conclusion is that the failure to correct by addressing Detective Kinney or Chief Bivens is consistent with the explicit racism exhibited in the attack against Judge Morrow and the treatment of Mr. Noakes. As to the third conversation, Judge Morrow guesses Ms. Chaffone's height. Again, context. Ms. Chaffone admits that that this was right after the arguing and the frustration that had been building in chambers. Not only follows right on the heels, it is a continuation. They now take issue with the guessing by Judge Morrow, but how did it actually happen? Pages 321 and 406, both of them put themselves behind chairs and a table. How could there be any overtly eyeing when they're standing behind objects? Second, the guest did not meet with upset or outrage, not even with impunity. Instead, it was greeted with an invitation by Anna Bickerstaff for the judge to guess again. I'm 5'3", if that's helpful. Even his guess on the weight only received the response, that's generous. The invitations repeated, the requests, the insistence have bothered me. They remind me of the case of Bowie versus the City of Columbia, 378 U.S. 347, 1964 U.S. Supreme Court.
Counselor, your time is up.
Thank you. May I have a 1-minute extension to wrap up?
1 minute.
Thank you. In Bowie, the two men walk into a diner in Columbia, South Carolina in 1960. They sit down to eat. The owner, who was behind the counter, walked around and put up a section closed sign for the section where they were sitting. Then called upon a police officer seated in a separate section and declared the two were trespassing. They were convicted. The U.S. Supreme Court overturned the convictions on due process grounds that having an open section, having invited the students to sit down, lulling them into a false sense of security, only for the owner to create a circumstance where charges and allegations were created. I see this as no different. I'm 5'3", Judge, if that's helpful. Thank you.
Thank you, Counselor. Ms. Weingarten, please.
May I inquire how much time I have left?
1 moment. You have 25 minutes from the total of 45. And we had basically discussed that council would have equal time. So you have the 25 minutes. If you need the extra 4, as Mr. Campbell did, you may have those.
Thank you. Judge, my responses to Mr. Campbell's arguments are not in any particular order. The first thing I want to talk about is Mr. Campbell's theory that the Wayne County Prosecutor's Office was out to get Judge Morrow. He makes this ridiculous claim based on no evidence at all. You heard testimony that Ms. Chaffone only knew Judge Morrow because she had co-tried a case as an intern 9 years ago. Other than that, in her involvement in this Matthews case, she didn't know him. Ms. Bickerstaff had never met Judge Morrow until her involvement in this case. Nobody asked Ms. Kinney or Mr. Bivens whether they knew Judge Morrow before, but if there had been an issue or if there had been bad blood between them, someone would have raised that issue. So you have to ask yourselves, are they the kind of people to make up lies to frame someone that they hardly even knew? And I submit to you that they are not. Mr. Campbell makes these allegations that the Wayne County Prosecutor's Office is out to get him based on stale evidence. They presented someone who used to be a prosecutor who is now a defense attorney, Ms. Nicole James. She testified that she stopped being a prosecutor in 2014. And before she left, there was a book kept on Judge Morrow about his indiscretions. You've heard no testimony that since 2014, there was a book kept on him. And given his history leading up to 2014, where he was suspended for refusing to follow the law, any prosecutor's office would keep track of a rogue judge and the things he said and did. It's a prosecutor's obligation to do so. Doing so does not suggest that the prosecuting attorney or her office is out to get the judge. Once a prosecutor's office makes a referral to the Judicial Tenure Commission, that prosecutor's office is out of it, except when their employees are required to be interviewed or testify at a hearing. It doesn't make any difference to the judicial disciplinary process whether the prosecutor's office as an institution likes, hates, or has no feelings toward a judge. This is an even stranger defense than it appears on the surface, because nearly everything the two assistant prosecutors testified to was corroborated by Judge Morrow himself in his answers. So nobody put words in their mouth to try to get him. This is just another claim by Mr. Campbell that is not only supported by the evidence, but it has nothing to do with the charges in the complaint. Counsel is right when he says that the two women did not use the words overtly I. That was language that we as the disciplinary counsel put in our complaint. But the two women testified about what Judge Morrow did. They demonstrated for you how he moved his eyes up and down looking at their bodies. And Ms. Chaffone said that no matter what word was used, the sentiment was the same. Then counsel tells you, well, there's no evidence of Judge Morrow's ill intent. Judges are governed by two bodies. One is the Judicial Tenure Commission, and one is the State Court Administrative Office. And judges fear getting in trouble with either one, if not both, of those two offices. He is told by both offices in 2004 and 2005, and Mr. Campbell can say it was one letter, but it was two letters from two separate agencies who did two separate investigations. He's told that his prior conduct was bad, and it's explained to him why it was bad. He's told how to proceed in the future. And then he does what he did to Ms. Bickerstaff and Ms. Chaffone. He made the choice to put himself in a situation where whatever thrill he got out of his conduct was worth the risk of himself getting in trouble again. Mr. Campbell talks about how Ms. Bickerstaff invited him to guess again about her weight. She testified she was offended, even if her words did not show that she was. But Your Honor has to use an objective standard to determine whether the judge was respectful and courteous or disrespectful or discourteous. Counsel argues that there are so many inconsistencies between Exhibits 6 and 7, the two memorandums that the two prosecutors wrote. You heard testimony that they did not work on them together, and that's evident because they don't read word for word the same. The content of what they wrote is very consistent. The only things Mr. Campbell could point out were discrepancies in whether Judge Morrow said would, could, or might have made her blush, which I submit to you is really insignificant. And my review of their memos reveals that the only difference you'll see is how Judge Morrow referred to Mr. Matthews' penis as a dick, according to Ms. Bickerstaff, or what he's working with, according to Ms. Chaffone. That's the only difference you'll see. And as you know, that's a distinction without a difference. Counsel discussed Judge Morrow's discussion of the directed verdict standard in chambers. And he said to them, you know, I can dismiss your case, right? Now, was that simply educating Ms. Chaffone, or was that a threat to hold over her head? Regardless, it played into why she didn't stop the discussion or fight with the judge more than she did. Then counsel tells you that it's appropriate to use sex as a teaching tool, but the right words fell on the wrong ears. Well, we had testimony from Assistant Prosecutor Joseph Curley. He was assigned to Judge Morrow's courtroom for 18 months. He got criticized and critiqued by Judge Morrow at least 15 times, if not more. During these discussions of critique, he never sat arm to arm in a chair with Judge Morrow. Judge Morrow never looked into his eyes and locked eyes and did not look away. Their heads were never a foot or a foot and a half apart. Judge Morrow never made sexual analogies, and he never used the words tease, foreplay, climax, crescendo to make his point. So it is not appropriate to use sex as a teaching tool. It's not something Judge Morrow did with male prosecutors or male attorneys, and it was completely inappropriate to do it with these young women. Then Mr. Campbell says, well, the disciplinary counsel did not call Mr. Noakes as a witness, and he's a race-just eyewitness. And of course, that's true. We did not call him in our case in chief. You heard from his testimony that he and I had an interview together in early 2020. And you saw his testimony. You saw his pompous attitude. You saw that he tried to protect Judge Morrow. What he didn't realize is that during this hearing, Many of his answers didn't protect Judge Morrow, but in fact corroborated the testimony of Ms. Bickerstaff and Ms. Chaffone and contradicted Judge Morrow's answers. So there was a good reason for us not to call Mr. Noakes in our case in chief. Counsel spent so much time in this hearing on whether Ms. Bickerstaff is a liar because she didn't correct a line in Mr. Bivens' report. And I'll be the first to say she should have made the correction. There's no doubt about that. But the fact that she didn't make the correction doesn't make her a liar. That's what he labels her, a liar. Not someone who's young or inexperienced or made a mistake, but a liar. When she reviewed the report at my request in preparation for this hearing, she told me about the error and I relayed it to defense counsel. If she were out to get Judge Morrow, she could have stuck with what the report said and testified that she did believe he was hitting on her. This would have caused her a lot less grief and it would have caused Judge Morrow a lot more grief. But she wasn't lying. She corrected the memo and told me and therefore Mr. Campbell about the error. So when Mr. Campbell says in his opening that without that line in the memo, we're not here today, that's absolutely crazy. One line in Mr. Bivens' report about Judge Morrow's comment to Ms. Bickerstaff, which she does not adopt, is not why we're here today. In fact, that demeans the seriousness of what Judge Morrow did say and what he did that justifies us being here today. We're here because of what he did, not because of what Ms. Bickerstaff thought about what he did. It's another claim by Mr. Campbell that was built without a foundation. Now, Mr. Campbell says that it's Ms. Chaffone's fault that Ms. Bickerstaff didn't correct the error. Ms. Chaffone testified she told Ms. Bickerstaff to correct the error, but she said she's an adult and I left it up to her to do. And I think beyond that, Ms. Chaffone had no obligation to do anything more. So as Mr. Campbell argued that without that one line, we're not here today. Well, Ms. Kinney testified that Ms. Bickerstaff did not say that to her, and Ms. Bickerstaff said, I didn't say that to her. The memos, Exhibit 6 and 7, which you'll read, and Exhibit 12, which is Mr. Bivens' memo, shows that there was so much more impropriety by Judge Morrow than that one alleged line that was attributed to Ms. Bickerstaff. Even omitting that one line, we would still be here today. That the case was appropriately filed because the allegations were so severe. Mr. Campbell then argues that the AP assistant prosecutors were overly sensitive, that they blew this out of proportion. They didn't blow anything out of proportion. All they have done is state the facts. Nearly every fact is corroborated, usually by Judge Morrow himself. It's up to the commission and to the Supreme Court to decide what proportion those facts should have. And to the extent that Mr. Campbell is suggesting that the facts are not serious enough to justify a complaint, he is simply wrong. The facts are serious and disturbing and an abuse of power by the judge who has authority and power over people. Then counsel, I think, argues that there are suspicious circumstances surrounding the transfer of the Matthews case to another judge. Your Honor has in evidence Exhibit 15, which is the transfer order signed by Judge Kenny. Under the rule he cites on the order, he has the authority to transfer cases. If Judge Morrow thought there was something untoward about it, he could have called Judge Kenny as a witness to testify about what he did and why he did it, or to explain whether his conduct was unethical or wrong. There is absolutely no evidence that the prosecutor's office or Judge Kenny or anyone did anything inappropriate in getting that case transferred out of Judge Morrow's courtroom. In fact, if it had not been transferred, that would have been inappropriate to put these two young women in the position where they had to practice law in front of this judge again. Your Honor, I hope you have seen that the allegations and the statements that Mr. Campbell made were did not amount to anything. He raised an issue, he took it and ran with it, and he tried to make something out of nothing. The people of the disciplinary council, thank you for your time and attention in this matter, and we hope that you find that he violated the codes and the rules of evidence, the rules of the court. Thank you.
Thank you, counsel. At this time, I am going to end the live feed on YouTube. We will discuss just the next timeline with respect to transcripts and whatnot. Is there anything further before I end this YouTube feed from either side? Ms. Weingarten?
Yes, does Your Honor want to cancel the sequestration order?
Certainly. Mr. Campbell, anything further from you?
No, thank you.
All right. At this time, I am declaring the proceeding ended, and I am canceling the sequestration order and also the order with the amended, both of those were amended orders, the amended order with respect to the witness and the hearing protocol. Thank you. One moment.